Yes.
Next, but I have to mention for this.
Mike.
Yes, I beg to mention for listing of a matter.
Yes. What?
It is for motion. It was listed on last Friday, but that was
Motion.
carried on for that.
Okay. Friday.
I'm obliged.
Your Lordship, I'm praying for listing of a matter for withdrawal, Lordship, a criminal petition, Lordship, on tomorrow, Lordship,
Tomorrow.
for withdrawal. Obliged, Lordship.
Please, I beg to mention item number 34 and 35.
Item number
34 and 35.
34 and 35. Yes.
Titles may be fixed next week.
Okay. On the prayer of Mr.
Here, Rahman.
A.R. Rahman, Learned Counsel for the petitioners in the two appeals or appellants in the two appeals. Come on. The appeals will be listed after a week. Ms. S.H. Bora, consent.
Maybe listen, Lordship. Lordship, item number 15, 1-5, my lord.
1-5.
One instruction of my party, my lord. I want for withdraw, my lord.
Okay, Mr.
A. Khalek.
A. Khalik, Learned Counsel for the petitioner, has submitted instruction that the petitioner wants to withdraw the criminal petition. Ms. S.H. Bora, Learned Additional Public Prosecutor for the respondent state, respondent number 1, state of Assam, is present and has submitted that state has no objection to the state prayer. In view of the above submission made by Mr. Khalik, Learned Counsel for the petitioner, the criminal petition is dismissed on withdrawal.
Obliged, my lord.
Item number 10, Your Honor.
Item number
10.
8.
10.
10, 10, yes.
Due to illness, I will engage counsel for the petitioner. I will
Okay.
not come today.
Miss, your name?
M. Sutradhar.
M. Sutradhar, Learned Counsel,
Next week.
has submitted that Miss R. Borua, Learned Counsel for the petition, revision petitioner, is indisposed and the matter be listed in the next week. First of MS S.H. Bora is present, has paid for, list the case in the next week on a date to be fixed by the office.
May I please, Your Lordship? With the consent of others, I beg to mention item number 37. That senior counsel Ijay Soike has some personal difficulty today. Kindly adjourn for the day.
You are for the petitioner?
Yes, Lordship.
Your name?
R.K. Mohanto.
Okay, Mr. R.K. Mohanto, Learned Counsel for the appellant has sought listing of the, has sought passover of the case for the day. It is submitted that consent has been made. Consent has been taken from the Learned Counsel for the respondents to make the prayer. The prayer is allowed. This is the case. The case is passover for the day.
Lordship, can he be 11 or 12?
Next week.
All obliged.
Yes. Okay. On the prayer of Mr. H. Buraguhai, Learned Counsel for the petition, and the case is passed over for a day.
Please, Your Lordship, I beg to mention for withdrawal of a criminal petition tomorrow.
Okay.
May I please, Your Lordship? Lordship, I beg to mention a criminal revision petition for withdrawal, Your Lordship.
Okay. Tomorrow?
Highly obliged, Your Lordship.
Release for motion. Item 1.
Yes.
May I be honored? Lordship, I am praying for list here, Lordship, transferring the case filed by the opposite party number 2 is the wife, Lordship, in the Sribhumi, Lordship, and petitioner is Lordship Khachar district.
Which litigation is earlier?
Lordship, my litigation is earlier, Lordship. She appeared, Lordship, regularly appeared in the Khachar, Lordship. And
What is the date of institution of your
Lordship,
case?
I'm Lordship, my case is Lordship. Page Lordship 11, Lordship.
Tell me the date.
Lordship, I have instituted, Lordship, the case, Lordship, 11/11/2024.
Okay,
And she lordship filed the case lordship. I have annexed lordship. Page 25 is the translated copy lordship, and 27 is the vernacular lordship.
okay, 25, okay, vernacular,
27 lordship.
yes, when it was
14
instituted.
Oh, it is lordship is 14/11/24. Subsequent lordship.
You instituted a case
Early.
where?
11 lordship, 11/11.
At which place?
In
Kachar.
Kachar district lordship. When she, in this case lordship, she appeared and regularly appeared lordship. She submitted her WS lordship.
Hmm.
I have also annexed lordship.
And you did not appear.
Lordship,
You did not appear.
lordship, I am lordship 60.
Where is the
Yeah.
summon?
Lordship, I have stated lordship, but
Hmm?
I have annexed the case.
Where is the statement? When did you receive? What is the distance?
Distance is 80 kilometers. Lord.
Huh?
80 kilometers.
80 kilometers.
Lord.
You are fit and fine?
Lordship, I am 63 years old, lordship, and along with
She is
me,
also, I think, of the same age.
no, lordship, 50 years, lordship, and what happened, lordship, we have a lordship son, lordship, who is mentally disordered, lordship, who is with me, lordship, and I have to take care of him.
Where is the document that mentally?
Lordship, mentally disordered, is the opposite party number 2, lordship, herself stated in her petition, lordship. I have, kindly see, lordship, page 25, lordship, I have translated it, lordship, the below, lordship. The name of the boy is Mayakdev Roy, aged about 27, who is a psychiatric patient. He herself stated the
Where is the vernacular portion?
particular portion is lordship. Page 27, lordship. 28. 28.
Yes, Ms. Bora, what do you say?
Jahannama.
Hmm. What is the stage of the
Lordship, appearance.
125 proceeding or 144 BNS?
Appearance.
If the institution by the husband is earlier, the distance is 80 kilometers. If the husband is taking care of the mentally imbalanced son,
Yeah.
it is stated, admitted by the wife.
By psychiatric patient that has been stated, but whether he's the petitioner that is.
He is with me,
Who
lord.
is taking care of the son?
Me, lordship.
Any statement?
I have stated, lord. I have stated, lord. Paragraph 7, lordship, I have stated. Repeat.
That is,
Mentally,
Para 7, lordship, below, lordship, the petitioner is now- page 6, lordship.
page 6.
Lordship. Here, one person and
Where?
page 7, para 8, lordship. The petitioner
Page
states that-
7, para 8.
The petitioner begs to state that he is a retired person and due to his numerous age.
Living with him.
Lordship,
Living with him.
yes, lordship.
Okay. Let us see what happens. We'll suspend the proceeding. You heard Mr. A.M.S. Mazumdar, learned counsel for the petitioner, and Ms. S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam. Post of the instant transfer petition under section 447, Bharatiya Nagorik Surakha Honita 2023 is preferred seeking transfer of a case, Miss case number 302/2024, instituted by the respondent number 2-wife of the petitioner, before the Court of Learned Judicial Magistrate First Class Sibhumi, to the Court of Learned Principal Judge Family Court, Kachar and Silsor. Full stop. The marriage between the petitioner, their husband, and the respondent number 2, their wife, was solemnized on 7/3/1996. Full stop. The petitioner has posited that they had spent 26 years of happy married life. Full stop. It was in 2022, the respondent wife deserted, left the house of the petitioner without left the house of the petitioner, and first of the efforts. It is stated that efforts made for reconciliation had failed. First of, what is the ground seeking?
Lordship,
What is on what ground?
for transfer, lordship, past lordship.
No, your divorce petition.
Lordship,
13
cruelty, lordship,
Huh?
on cruelty, lord.
Okay. The petitioner, on 11/11/2024, instituted had filed a petition under section 13(1) within a small IA of the Hindu Marriage Act 1955 for dissolution of his marriage with a respondent number 2 wife by a decree of divorce. Post-op. Subsequent to the institution, and the said petition was registered as FC Civil Case number 546 of 2024. Post-op. Summons were issued to the respondent number 2 wife for appearance on 11/11/2024. Post-op. Thereafter, the respondent number 2, that's wife, entered appearance and had filed a written statement. Post-op. Para. The respondent number 2, that's wife, on 14/11/2024 has filed a petition under section 144 B and SS before the court of Chief Judicial Magistrate. Sribhumi, seeking maintenance, monthly maintenance of rupees 25,000. Post-op. The said petition has been registered as Miss Case number 304/2024. Post-op. Para Mr. Mozumdar and Counsel for the petitioner has submitted that summons has been issued in Miss Case number so and so 302/2024 for his appearance. Post-op. And seeking transfer of the said proceedings under section 144 BNSS, the instant criminal petition has been preferred. Post-op. One of the grounds seeking transfer is that the petitioner, husband, and the respondent number 2 wife have a son which is at present is about 26 years of age, Full stop. But their son is a mentally imbalanced person and he is living and it is the petitioner who is taking his care as he is living with him. Full stop. Issue notice returnable and 4 weeks. As Ms. Bora has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Notice to the respondent number 1, formal notice to respondent number 1 is not necessary. Extra copy, 3 working days. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 as well as by usual process within 3 working days from today. Having regard to the projections made that the institution of the proceedings under section 144 BNSS is subsequent to the institution of FC case number so and so, and the petitioner is taking care of their mentally imbalanced child as he is living with the petitioner, it is ordered, in the interim that the proceedings of this case number 302/2024, presently pending before the Court of Learned Chief Judicial Magistrate Sribhumi, shall remain suspended till the returnable date.
Number 2.
May I pray, Lordship? This petitioner company, Lordship, is a coal mining company that was incorporated under Companies Act, Lordship. I have annexed all the documents regarding the that incorporation of the Nature 1, Lordship. And this company purchased some 1,490 metric ton of coal from one Messrs. Dominic Marthang from Shillong, Lordship, who is an auction purchaser. And that was, and they kept the same in their depot at Jugigupa, Lordship. While the that coal amounting to 53.00.
Let us go one by one
Yes,
document. We have annexed so many documents.
Yes, Lordship. Lordship.
Okay, you have certificate of incorporation.
Yes, Lordship.
Resolution, and you have entered into an agreement
Yes, yes.
with Dominic Midfong.
Marthang. Yes, Lordship.
For what purpose?
For the purchase of coals.
For the purchase of coal.
Yes, Lordship.
Where government auctioned Meghalaya coal.
Yes, Lordship.
Okay.
Then,
Quality of coal supplied by the petitioner shall have gross. What is the quantity mentioned
yes.
somewhere?
Yes, they. No, that is,
Is it mentioned? No, is it
Yes,
mentioned in the agreement?
page 26, Lordship.
26.
Yes.
Yes. Any amount is mentioned?
1490.
1490 metric
Metric
tons. Okay.
And that is the GST number. Also.
You have said seller has legally purchased
Yes.
Meghalaya coal,
Coal.
auctioned by the government of Meghalaya.
Yes.
Okay.
Yes, Lordship. Then,
So what happened then?
Lordship, the.
Let us take to the next document.
Yes, Lordship.
What is this, page 36? E-way bill.
E-way bill, that is GST paid by the for 53.00 metric ton for
Where it is mentioned 53.
Lordship. Thanks and human home. Yeah, that's it. That's it.
Quantity is mentioned.
Yeah, yes, Lordship. I'll show. I am.
E-way bill.
Yes. That's an E-way bill. Yeah, that's it. I told you, Ali, about it. Yeah, yes, this one. Not this one yet, like us.
It was generated on 6/4.
Yes, Lordship.
Valid up to 9/84.
Yes, Lordship.
Place of dispatch Jugigupa.
Jugigupa to that Assam coal company to put goods. It was Assam.
Purvanchal Cement Limited.
Yes, yes, Lordship.
Okay.
Yes, I will. It is Purvanchal Cement.
Okay. Then It was seized on 9/4, beyond the UA bill date.
Because it is a late night, 8/4/99, they detained the truck lordship.
Okay, midnight,
Midnight. That is where
2 AM, okay.
mm,
One Tata QC vehicle, okay, 53 ton.
93.
Okay,
26.
53 ton in connection with Bokhista Police Station 188/2025.
Yes, lordship.
BNS con 20%, BNS con 20%.
It is
What is
annexed
61(2)? Because I am not familiar with BNS offenses. BNS.
61 criminal conspiracy lordship.
Okay, and 305?
305 theft from
Theft.
stolen property from government stolen property lordship.
Theft.
Yes, lordship.
305. Okay, theft. E. Of any property of government. Okay.
Yes,
53 ton. Seized.
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 Yes. That-
Then from Sakayat Khan,
Yes, vehicle.
Dinesh Vishnu Mandal,
Yes, to helper and driver was
the helper and driver.
driver.
Then what is page 52? Okay, 9/4. Okay, they were taken into custody.
Yes, lordship.
Then thereafter on 8/5, 8/5 they were granted bail.
Yes, lordship.
Okay. Then what is this page 56? This is the FIR.
Yes, lordship. That is the main page 50.
Those are up
I am
to
not,
29/3/2025. This
Yes.
FIR
and my car.
that has been registered. Okay, that has been registered as 188. Tilaka Paul.
That is different vehicle and that was registered on 30th March, 30th
But
March.
police station case number is same.
Now they have implicated me in this case. Lordship.
Police station case number is same.
Same, but that was registered on 29/3/25.
So that was a different truck and
Yes.
different driver.
Yes, lordship.
Twenty-four.
And my-
Representing is a file to petition. Come to page 63. Seeking Zimma and coal. Vehicle. Coal quantity. Now come to the report. Page
Page
64.
64, first report, lordship.
I have the honor to report that I have received a kind order where I am also submit my report. GRM started in connection with the defense case. That I was submitting the student has seized vehicle, which was seized in connection with reference to the so vehicle number, bearing number so and code was seized in connection with the instant case. Further investigation. The register of the code could not be verified during the time of apprehension of helpers. So report is to the effect that at the time of seizure, the driver failed to produce documents. That is a report,
That is
whatever.
the
Let us go.
Yes, lordship.
We'll wait
That
for your submissions.
Yes, lordship. That is the report.
Then you file a petition.
Yes, lordship. On 24/4/2025.
Where is that?
That petition I have.
That vehicle was granted.
No, lordship. Vehicle was still with that is loaded.
Investigation. I produced the Zima report.
There are-
Seized in the same vehicle is still required. Okay. Then you file petition for coal or vehicle both.
I have filed 2 petitions here, lordship. Separately for coal.
Okay.
I am the owner of the coal.
Okay. You claim the custody of both.
No.
By separate petition.
Separate petition because driver is the sorry, one Jaur Rahman was the is the driver sorry,
Coal mining.
owner of the truck.
Let us see the impugn order.
That is in the page
73.
74. '74, Lordship,
73 is the first initial order.
orders.
Did you annex all the documents?
Yes, Lordship. All the documents,
All the documents?
Lordship. I have submitted all the documents before the
Is
Won't be
it one of the honor reports that
because you did. And actually what you did, so I said, mention.
Ms. Bora, come to the order, page 73. The case record, let us read together. The case record is put up today on the strength of petitions by number so-and-so, by the respective petitioners seeking zimma of a vehicle and coal, as mentioned in the petition. Heard, before passing any effective order on the petition, I would like to call for a report from the IO to the effect that 1 to 3 questions, right? Question number 3. Whether the respective petitioners are the registered owners of the seized vehicle and the articles as mentioned in the petition. IO shall specifically answer the above question in his report and submit the same before this court on the next date fixed. Right. Then there is one bold paragraph in bold. Then thereafter, IO is directed to verify the annexer and to submit a report of verification along with a reply of the above questions. Right. Now turn to the next page. 74. Now read the third paragraph. It is stated in one of the reports that the vehicle number so-and-so and the coal quantity 53 ton were seized in connection with this instant case and the same are required for further investigation of the case. It is also stated in the report that ownership of the above mentioned document and the coal could not be verified, as no person has appeared before the IO nor submitted any document supporting the ownership of the seized item. So IO was directed to verify the annexers and to submit report of verification. But he says,
Directed something regarding of the regarding the seized coal. That record with the kind of the report has come. Because seized coal is yet to be ascertained.
15 times we went to this. Yes.
have you not submitted the documents with the IO also?
Yes, Lordship, I have 15 times we went, Lordship, along with the owner and truck driver, everybody.
This report, so far, this report is page 76. At least the VUA bills, then this agreement, and UA bill says about the vehicle also, same vehicle, QC so-and-so. All these documents
Lord,
is primarily suggestive of the fact that they had done it through that vehicle. And it is government auctioned, Meghalaya government auction as per the agreement. There is nothing of that sort because the court directed that to verify all these documents, annexes.
That effect of declaration would affect that.
This report reflects nothing about coal. Huh? Seize coal. There is nothing. No. As they failed to provide any legal document in support of coal, right? The ownership could not be verified. But the documents annexed here are, there is no report, no comment of the IO. In the order, in the impugn order, it is reflected. See page 74. It is also stated in the report that ownership of the above mentioned documents and coal could not be verified as no person has appeared before the IO nor submitted any documents supporting the ownership of the seized item. And page 73, IO is directed to verify the annexes. So with a petition, custody petition, the petitioner might have annexed the documents, agreement, etc. There should have been some remarks. It appears not.
That what we.
Yes, in this report also, there is nothing. It has been charge-sheeted already.
No,
No, case has been charge-sheeted. Case has been charge-sheeted. So far vehicle is concerned,
yes, Lordship,
they have given a green signal.
Lordship,
They have given a green signal to release,
yes,
right?
Yes,
But so far coal is concerned,
yes, Lordship.
right?
Yes, Lordship.
Now, to facilitate early disposal of the petition, whatever you have annexed,
Yes,
I'll observe in the order that you submit those documents within a period of, say, today is what? 28th. If you submit the documents within 1st of August, within this week, 1st of August, all these documents, supporting documents, and IO should place a fresh report before this court within a very short time. So far coal is concerned,
Lordship, in this case, coal is inside the truck till today. And the police has demanded, I have mentioned in my petition, I filed a writ petition against police also.
that is a different matter. We are not
Different
into.
matter, Lordship.
No, you submit the documents, otherwise,
We have, Lordship, submitted 15 times, we went
no,
to there.
with a express direction of this court,
And
I have made it clear that you submit the documents, whatever supporting documents you have annexed with this petition to the IO within 1st of August, because your impugner says submitted edit so and so. We can set aside this order and send it back to the court again.
yes,
But I am trying to expedite. If you still insist, then I'll set aside and send it
no,
to the court.
Lordship, that is not my submission, Lordship. Because the coal, they have detained the truck on 9/4. In connection with that case, where my name has not been shown, my truck has not
Madam,
been
this has
Yes,
come
Lord.
for the first time. You want a quick fix order.
No, last occasion of case was listed, Lordship, and a
No,
report
I have
was-
seen now the
Yes, Lordship.
materials on record, but this record again says failed to provide any legal document.
We have submitted before lower court also.
Heard. Miss M. did. Learned counsel for the petitioner.
What's the name? What's that? 11?
And Miss S. H. Bora, learned additional public prosecutor for the respond number 1, State of Assam. Poster. The instant criminal petition under section 438, read with section 442, BNSS 2023 is preferred to a sale an order dated 6/6/2025, passed by the Court of Learned Subdivisional Judicial Magistrate within bracket S-Roman 2, Kamrup, M, Guwahati. Order dated to assail an order dated 6/6/2025, whereby a petition filed by the petitioner seeking interim custody of 53 tons within bracket approx of coal
Metric
seized in connection with Bokhista Police Station case number 188 of 2025 has been rejected. Post of para. Initial. On 30/3/2025, upon interception of a vehicle bearing registration number AS-01/DC-3405 within bracket Tata 901, and upon recovery and seizure of suspected stolen coal, a crime case, the case, Punapur Police Station case number 188/2025 has been registered on 30/3/2025 for the offenses under section 62 within bracket 2 and section 305 within bracket E, Bharatiya Nyaya Honita 2023 BNS. Post on. Subsequently, on in the early years of 9/4/2025, another vehicle bearing registration number AS-Q1/QC -9326 within bracket the subject vehicle, loaded with 53 tons within bracket
metric ton,
approx.
lordship.
Huh?
Metric ton, MTS.
MTS likhibo. Of coal approx, was seized from one Sakayat Khan driver and Vishnu Mandal helper. Post of para. It is contended that the petitioner is an incorporated company dealing with coals. Post of on 20/11/2023, it entered into a sale and purchase agreement with one Mr. Dominic Mirthong for purchase of 1490 MTS of coal auctioned by the Meghalaya government via MSTC. Post of. The quantity of coal, 53 MTS approx seized on 9/4/2025 was part of the coals, quantity of coals purchased by the petitioner pursuant to the said agreement. Full stop. In support of such claim, the petitioner has annexed EUA bill authorization certificate, etc. with this petition. Full stop. Para. When a petition for interim custody of the seized coal of weighing 53 MTS approx was preferred, the learned SDGM on 22/05/2025 framing 3 questions, call for a report from the IO. So the IO was also directed to verify the annexers and to submit a report of verification along with a reply of the said questions. Full stop. But the IO submitted a report stating that the ownership of the subject vehicle and the subject seized coal could not be verified as no person had appeared before him and no documents in support of the ownership of the seized items were submitted before him. Full stop. Taking note of the said report, the learned SDGM by the impugn order dated 6/6/2025 has rejected the petition for interim custody filed by the petitioner in respect of the seized subject coal. Full stop. Hence the criminal petition. Full stop. Para. Today, MS Bora, an additional public prosecutor, has submitted a report from the IO dated 24/7/2025, as called for by the order dated 16/7/2025. Full stop. In the report, the IO stated that the case has been investigated and thereafter, a charge sheet by charge sheet number 278/2025 has been submitted against the apprehended accused persons on 29/6/2025. Full stop. The report has further mentioned that despite given ample opportunities, with regard to time, the driver and the helper failed to produce any valid documents, legal documents in support of the coal being transported. Full stop. Para. Apparently, there is no reflection in the report submitted by the IO at the time of passing the order dated 6/6/2025, reflecting that he had verified the documents within bracket annexes submitted by the petitioner with regard to its claim of ownership for the seized coal weighing 50 MTS. Full stop. Privacy, comma, the impugned order dated 6/6/2025 has been passed without any observation on the documents submitted by the petitioner in support of its claim of ownership for the seized coal weighing 53 MTS approx. Full stop. In the report dated 24/7/2025, there is no reflection that the IO had considered the documents which the petitioner has relied as regards its claim for ownership in this petition, annexing those as Annexer 1-2, Annexer 11. Full stop. Well, in the above period of matter, the petitioner is directed, petitioner is allowed to submit the aforementioned documents before IO on or before 1st of August 2025. Full stop. It is further observed that on submission of the aforementioned documents, the IO shall furnish a fresh report invariably on or before 7th of August 2025, release the case on 8/8/2025.
Thank you. Second matter is regarding the vehicle lordship. Three.
Vehicle custody document কি আছে চাওঁ এই যে হেৰিকেইটা আছে এইটো কণ্টিনিউ কৰি দিয়ক একেখিনি কথাই কণ্ডিশ্যন যে আছে চাওঁ প্ৰথমখিনি একেই হ'ব অলমষ্ট things are same up to the impugned order.
Yes, lordship.
What are the vehicle documents annexed here? Show me the page.
Yes, lordship.
Who is the petitioner here?
Giauro.
Okay, petitioner to actually incorporate company asil no এই লাইনটো চেঞ্জ কৰি দিব the petitioner
Itu বেলেগ file.
has claimed that he is the registered owner of where are the annexers please
বেলেগ file এটা আহিব।
of a vehicle bearing registration number AS01/QC9326 sound custody condition কি দিয়ে
আৰু এটা file বিচাৰি আছিলো যে সেইটোৱে।
প্ৰথমে সেইটোৱে দিব পুস্তক হা তাৰপিছত এই পুলিচ ষ্টেচন গোটেইখিনি কেছখিনি চিজাৰ টিজাৰ গোটেইখিনি যে আছে সেইখিনি দি দিব হা তাৰপিছত ইম্পিউন অৰ্ডাৰলৈ 6/6/2025 আছিল ন সেইখিনি দি দিব আৰু ৰিলেটেড টু কোল যিখিনি আছে ন সেইখিনি ডিলিট কৰি দিলে হ'ল Impugn order to likhibo. Where is the impugn order here?
That is annexure 17, page
That is
58.
interim custody for heavy lease, no? Cold lease, no? Interim custody or subject vehicle likhibo. Huh? Particulars to হেৰি লিখি দিব ব্ৰেকেটৰ ভিতৰত এই টাটা LPT আৰু ডকুমেণ্টখন চাই ল'ব পেজ এই হেৰি বা পেজ 20 বা চাই ল'ব CC's number engine number privacy from the registration certificate Annexer 1 authorization certificate of NP permit Annexer 2 motor insurance certificate cum policy schedule Annexer 3 pollution control certificate Annexer 4 driving license of Mohammed Saket Khan Annexer 5 driving license বাদ দিও EUA bills Annexer 6 EUA bills Annexer 6 and a seizure list Annexer 8 it can be noticed that the petitioner is a registered owner of the subject vehicle, which was seized on 9/4/2025 in connection with Hunapur Bukhisto Police Station case number 188/2025. Full stop. In the report submitted by the IO, in the report dated 24/7/2025, submitted by the IO, it is mentioned that as per the data retrieved from E-Salan system, the petitioner is the registered owner of the vehicle, of the subject vehicle, and the subject vehicle can be considered for release on Zimma upon production and verification of the original ownership documents. Full stop. The petitioner so coal is loaded already. To unload, or if you can wait up to 8/8, we can coal and the vehicle can be released together. I am releasing the vehicle,
Yes.
but it has to be unloaded. It is up to your call. It is your call now.
On 7/5 also, they have given same report.
No, we are
Yes,
we are ordering custody, but the
Yes.
the vehicle is with the coal, but coal is not.
and we have hired the vehicle.
Oh no, not
That-
coal is yours
Yes, Lordship.
because this coal is to be unloaded.
Unloaded.
In
and
the
then
process of unloading, something may be missing. Then you don't.
we are paying money to the driver, the owner of the vehicle.
No, they use the vehicle is in the police station. right? Loaded with coal,
Coal.
53 MTS approx. Now to release the vehicle now, the coal loaded therein is to be unloaded,
Yes, Lord.
right?
Yes.
In the process, the other petitioner's coal, some loss may be caused
Yes.
in the form of something. It is up to you. It is your call. Sundar bhai ne kyota asle Sundar bhai. Sundar bhai, you know, Ambalal to sound. Oh, এটা নোলাই নেকি? টেবলেটটো আনক নহ'লে। এতে আছে জানো? নাই। The petitioner has averred that since the subject vehicle was seized on 9/4/2025, the subject vehicle has been kept in open condition without any proper care and protection, and the same is in the process of the same is likely to be damaged,
Sundar bhai.
are likely to be damaged due to heavy rainfall, etc. Keep to Marido. Full stop.
এখানে কোড করা আছে প্যারাগ্রাফ 2 another piece.
It has extracted paragraph 4 of some other judgment. বুজিলো এটা আছে নেকি নাই
একটু লিখি
চাওঁ দিয়ক
আছে তাতে বেকসাইড
ক্লিপটো মাৰি দিয়ক
একটু জয়েন্ট আপু প্যারা 4 ইনটু
No, that is something else. Basava Kom Doymonda, not Sundar Bhai.
it was extracted in para 4 of the judgment delivered in this.
No, the line object of section 451 of the CFG is well defined by the Supreme Court in the case of so and so. When the Supreme Court have extracted paragraph 4 of the judgment of Basava Kom, not Sundar Bhai, which you have shown now. সুন্দর ভাই নাই দারুণ সুন্দর ভাই
That's
আর here he was Sundarbai Ambalal Desai, State of Gujarat. 2002, 10 SSC, 290. कैसे आ सकूं? From the report of the IO dated 24/7/2025, comma. It can be seen that the charge sheet has only been submitted against the apprehended accused persons, comma, that is the driver and helper of the subject vehicle. Meaning thereby, comma, the petitioner, who is a registered owner of the subject vehicle, comma, has not been charge sheeted in charge sheet number 278/2025. Full stop. The petitioner has all the necessary documents in support of his claim for ownership of the subject vehicle pulled up. In fact, having regard to the report dated 24/7/2025 of the IO, wherein he has stated that the subject vehicle can be considered for release on interim custody upon production and verification of the original ownership documents, comma, it is ordered that the vehicle bearing registration number so-and-so, subject vehicle seized in connection with so-and-so case number, be returned to its registered owner, that is the petitioner, subject to the following conditions. Indemnity bond of, what is the condition normally? With one surety. Indemnity bond of. How it is to be measured? Ms. Bora? How much indemnity bond?
For the cost of the property.
Huh?
The properties.
Amount of the property is struck only. Gold we are not discussing. What is the amount? How? 7 lakhs. Let us see the insurance. Yes. His declared value is 42 lakhs. Huh?
Page 20.
Yes. Turn to next page, madam. Yes, Ms. Dev. Your declared IDB is 42,46,608. Page 23. Indemnity bond. I am not asking for bank guarantee. Indemnity bond of an amount of, for an amount of rupees 42,46,608, which is the insured declared value IDB of the subject vehicle, comma, with one surety of the same amount before the learned trial court. Para 2, the petitioner shall produce the seized vehicle before the learned trial court as and when called for during the trial, also during the confiscation proceeding, trial. The petitioner shall not alienate the seized vehicle or change the nature and character of the said vehicle during the pendency of the trial. The petitioner shall also give an undertaking that he will not use the vehicle for any illegal activities in future. The petitioner shall provide the particulars pertaining to the movement of the said vehicle to the investigating officer of the concerned police station. There shall be no orders to proceed with the above everything. The criminal petition is disposed of. The report dated 24/7/2025 submitted by the IO is kept with the case record.
Number 4.
Briefly, Your Lordship. The matter relates to granting interim maintenance to the opposite party. The matter relates to the granting of interim maintenance granted to the opposite party, Your Lordship.
Yes.
Interim order, impugn order, kindly see page number 28, Annexure 4, Your Lordship. Annexure 4,
40,000 salary,
yes, Your Lordship,
12,000
12,000.
interim maintenance. What
Yeah.
wrong?
Your Lordship.
What wrong?
My lord, she left the house of the petitioner voluntarily, Your Lordship.
Voluntarily.
With the
That is a
petition.
subject matter of appreciation later on. This is interim maintenance only.
Yes, Your Lordship.
Whether she left voluntarily or involuntarily, that will be decided by the court.
Yes, Your Lordship.
Huh?
But the petitioner.
What are the other grounds? What other grounds?
Your Lordship, I have set forth 4 grounds, Your Lordship. Page number 5, Your Lordship, kindly see.
Page number 5.
Your Lordship, she is a BSc, Your Lordship, working as a teacher in
BSc
BSc, Your Lordship.
teacher.
Teacher.
Where is the
It
state?
is Manipur, Your Lordship.
Where is the statement?
It is in my
Where is the statement?
statement. It is in statement number 10 of written statement. Your Lordship.
Page.
I'm showing, Your Lordship. Para 10, page number 14, Your Lordship.
Page number 14.
148. That the second party denies the statement made by the first party as such. The first party is spending a kind of poverty life without any economic support.
Capable of earning is different thing. At present working.
Working, Your Lordship. BSc past capable of earning for livelihood and at present working.
This is in your written statement.
Written statement, Your Lordship.
Okay. That is one.
Yes, sir.
But still 40,000.
I have, sir.
Hmm?
I have in my affidavit.
Date of marriage, date of separation.
Separation 12/12/23, Your Lordship. Date of marriage was 27.
Mother is dependent.
Mother is dependent and she is a sick person, Your Lordship. She is a sick person, Your Lordship.
Sick person.
Yes, Your Lordship.
Your name is Tutu Rai.
Mother is sick.
Tutu Rai.
I am to repay loan for my mother.
China border. Army.
Army, Your Lordship.
Mother is not dependent. Your father is serving.
He
Mother is not dependent.
actually,
Your father is alive and he is serving at Guwahati. That goes.
actually.
Mother is not
separated-
dependent. Mother is not dependent.
Ma- His
Come to your
Yes.
own pleading, page 13.
father is there, Your Lordship, but he is
Father is there and he is serving in Guwahati
so he is not living.
in job.
His
So
job, but he is
father
not
takes
living-
care of your mother.
He is
not
living
you.
with his mother, Your Lordship.
Huh?
He is not living with my mother.
Huh?
He is not living. He is not with.
Because of service, he is staying in Guwahati. Mother, father, everybody took care of her.
Father.
Your
actually-
statement, madam.
Father actually.
Madam, your statement. Don't try to. Paragraph 9. All the way together. That goes. And when did you submit this statement of assets and liabilities?
Assets and liabilities submitted. Submitted, Your Lordship, please.
When? Prior to the impugn order or subsequent to the impugn order?
11. 11
Marriage
to
between
18.
insurance or something, it is case is not residing in a parent, moreover, it doesn't have a. Doesn't maintain the second body, a bit of he is working as a sipahi. Yes, right. 24/4. What is the date of submission of statement of assets and liabilities?
Your
Please
Lordship.
tell me. Is it part of the written statement? Or you are turning the leaves here?
Your Lordship.
When did you file this written statement?
No, that verification order. may- I think it is filed before,
Before the impugn order?
before impugn order, Your Lordship.
There is no date nowhere.
No
That
date.
is why.
No date.
No date, neither in the verification.
Part of it is before, before passing impugn order, Your Lordship.
Huh?
Before passing impugn order, Your Lordship.
ওলালে ও লাগিব বেলেগকে চব লাগিব Okay, hard miss.
Here we go.
Yeah, Begum, learned counsel for the petitioner. Post. The instant. Why did not you approach the okay family court? Is it family court?
Family code, Your Lordship, Borpeta.
Family court Borpeta. Okay. So it is a criminal revision petition, okay? The criminal revision petition under section 19 within bracket 4, comma Family Courts Act 1984 is preferred to assail an order dated 24/4/2025 passed by the learned Principal Judge Family Court Borpeta, whereby the learned Family Court has granted interim maintenance of rupees 12,000 per month to the respondent hearing on an application filed by the respondent before the said court under section 144 B ভারতীয় নাগরিক সুরক্ষা সংহিতা 2023 within bracket earlier, comma, section 125, comma, Code of Criminal Procedure 1973. First of, it is the contention of the petitioner that on receipt of notice from the learned family court, comma, the petitioner had filed written statement along with a statement of assets and liabilities in the prescribed form enclosure dash Roman 1, post of the petitioner had stated that he is in service in the Indian Army, comma, 7th Assam Regiment as a sepoy, and his monthly income is rupees 39,012 after deduction. Full stop. The petitioner has taken a loan of rupees 12 lakh from the State Bank of India, for which he has to pay a monthly installment of rupees 19,369. Full stop. In addition, comma, he has to pay monthly installments for other items purchased with finance from different finance companies. Also, as a result, comma, the final amount received by the petitioner is around 16,000. First of one other in comma. The respondent is a BSc, has the qualification of BSc, and is presently working as a teacher in Krishnananda Academy, Manikpur, comma, Borpeta. Full stop. Around 14,000, not 16,000, 14,196. Full stop. As such, comma, the interim maintenance amount of rupees 12,000 is on the higher side. Issue notice returnable 4 weeks. The petitioner selects this for service of notice on the respondent by registered post JD, as well as by usual process within 3 working days from today, having regard to the projections made by the on behalf of the petitioner and the statement of asset and liabilities, comma, it is ordered, comma, in the interim, comma, that the petition and the order, sorry, it is ordered that the petitioner is ordered in the interim that the petitioner shall pay an interim maintenance of rupees 8,000 from the date of filing of the application, comma, FC criminal case number 48 of 2028 till the returnable date, meaning thereby first of the order of interim, the imperial order of interim maintenance dated 24/4/2025 stands modified to that extent.
Six.
Dari kan pas dulu sapu lidik dari kan. File kita lu sapu nuari lagi. Yes, Mr. Sigdar.
Your Lordship, my lord, here the petitioners are two of the parents of the
Yes.
main respondent, my lord.
Hmm.
The
complainant wife
Okay,
has
but
filed the TV case against the,
concurrent finding of fact,
but
concurrent finding,
my lord,
what is the final
That-
result now?
final result is, my lord, we are agreed that we are also, the direction is also given against all the appellants, my lord. And we are the parents,
Now, what is the direction? Let us see.
my lord. As paragraph 47 at page 118.
Appellant side. Appellant side consists of whom?
My lord, the
These two
parent,
petitioners.
these two petitioner, including the
What are
husband
the
of the
name of these two
complainant.
petitioners?
My lord, our stand is that the complainant, wife of the respondent number one, never
Of
decided.
Babadhan Rupavati.
Yes, my lord. She
You are respondent,
resides in a rented house.
appellant number 2 and appellant number 3. And your son,
Brajendra is
Brajendra
the
Singha is the respondent number 1 and appellant number 1.
one.
Appellant side is directed to so and so on about so per month, monthly maintenance or something. So 1 lakh compensation.
Yes, 1 lakh compensation. Pay 22,000.
All areas,
maintenance.
interim maintenance and monthly maintenance within 3 months. Monthly maintenance 22 lakh, pay 22,000. Payable with effect from the date of filing of the original DV. That is from 13/2/2020. Appellant respondent number 1 is directed to accommodate a rented room. 11,000. So basically 1 lakh. 1 lakh.
1 lakh is the
Right.
my lord, yes,
One.
my lord.
1 by 1.
Yes.
1 lakh compensation.
Yes.
Then the husband has been directed to pay 11,000.
When the direction is against the
11,000. 11,000 as monthly rent. And plus, lastly, 22,000. So if your husband is obeying, what problem you have?
My lord, the husband.
Basically, it is directed to the husband.
Husband, my lord. But
Concurrent finding of fact.
But the fact is, my lord, it is.
Now, what
of-
illegality or impropriety? Because we are in revision now.
My lord.
Concurrent finding of fact.
Well, there are so many anomalies in the finding. First
Okay,
point is-
anomalies will not do anything. Mr. Sikdar.
My lord.
Legality, propriety, and correctness, not anomalies.
Yes, my lord.
We are in revision.
Revision. Yes.
Concurrent finding of facts reached by 2 courts,
Subordinate.
right?
Yes.
We are in revision. So our scope is limited. Legality, propriety. What illegality the trial court has
My
committed?
point is the liability of this appellant, present appellant. The complainant never reside with the parents of the husband. Never reside. She reside with the husband for some areas. Then after return, she reside in a rented house.
Whether this appellant number 1 has preferred any appeal.
My lord, so far in my instruction, he is also filing.
Let him file, then we'll decide. Otherwise, one specific direction is 11,000 specifically against him. 11,000. Right? And 1 lakh at one time. And 22,000 for all. We'll examine. Let him continue. Because concurrent finding of fact, the appellate court has also agreed to that amount. We'll examine this issue.
My lord.
Matter of appreciation of evidence.
My lord.
And legality, impropriety, correctness. Not anomalies here and there. Pick up 1, pick up 2nd, pick up 3rd. No.
My lord.
It has to be expressive. Will issue notice at this stage.
My lord.
Heard Mr. A.R. Sikdar, Learned Counsel for the petitioners, and Ms. S.H. Vora, Learned Additional Public Prosecutor for the respondent number 2, from State of Assam. The judgment. A judgment
My lord, it is.
An order dated 35/2025 passed by the Learned Additional Session Judge FTC at Kasar, Silsor as an appellate court in criminal appeal number 02 of 2025 and a judgment and order page.
My lord, judgment, appellate judgment at peace.
A final order dated 26/12/2024 passed by the Court of Learned Judicial Magistrate First Class Lakhipur, Silsor in Miss DV case number 05/2020, case 44 are under challenge. First of the appellate court has affirmed the judgment of the Learned Trial Court with certain modifications. First of the appellants consisting of the husband, the father-in-law, within bracket the appellant number 1 herein, and the mother-in-law, appellant number 2 herein, have been directed to pay a sum of rupees 22,000 per month towards monthly maintenance of the respondent wife of the appellant number 1. Of the respondent wife. Full stop. The appellant side has also been directed to pay a sum of rupees 1 lakh as compensation. Full stop. The husband of the respondent number 1 has been directed to pay a rent of rupees 11,000 and to accommodate a rented room in Guwahati. Post of issue notice returnable in full. A number of contentions have been raised to assail the judgments. Post of it transpires that the same for deciding the same, appreciation of the evidence may be necessary. Post of, however, the scope of the revisional jurisdiction is limited to the legality, propriety, and correctness.
My lord, my
Post of
submission
issue
of
notice
that,
returnable in 4 weeks. The petitioners shall take steps for service of notice. As Ms. Bora has appeared, extra copy. The petitioner shall take steps for service of notice upon the response number 1 by registered court with AD as well as by legal process within 3 working days from today.
my lord, my submission is that their parents, husband, he may have a good case against husband, but parents are to be exempted. That is my plea.
Sigdar, we are not denying that parents might be exempted, but the question is that it is a concurrent finding of facts which should not be touched and interfered lightly. It is to be heard and thereafter. I am not denying your submission, but it is a case of revision. 2 courts
My lord,
have reached the finding.
my lord, we are old parents, only 79 years, 76 years.
So your son,
Sir, we are in the.
your son should be an obedient son.
It's your name.
My lord.
Oh, this here we call for.
Item number 7.
Hey, please, Your Lordship.
Hmm.
Chip, this is a criminal revision against our prayer for
Custody.
custody.
Any order has been passed.
Lordship, 2 orders were passed.
Let us see the orders.
Page 83A, Your Lordship will find. 83A, page 83. May I read, Your Lordship? Order dated 2/5/2025, petitioner of Jimma petition number 240/25, dated 10/4/2025, is represented by learned and engaged counsel. Informant Sri Vidyut Sarkar is present. I've heard the learned counsel for the petitioner of aforesaid Jimma petition as well as the learned APP appearing for the informant. At the time of the hearing, learned counsel for the petitioner of Jimma petition number 240/25 has submitted that the petitioner could not obtain document relating to dispatch of another consignment of 32 tons TMT bars to the petitioner as transporter for supply of same to the informant. The learned counsel has further submitted that in the absence of such document, the petitioner did not have any objection if the seized 29 tons of TMT bars are released to the prosecuting department. Here is the case record. Upon perusal of the case record, it is seen that the petitioner of Zimma petition number 240/25 is admittedly engaged by supplier Sham Steel Industries Limited for supply of seized TMT bars to the informant. Also admittedly, the informant had already been made payment of price of the aforesaid seized TMT bars to said Sham Steel Industries Limited, and in this regard, the informant has submitted copy of tax invoice in this case along with his petition number 306/25 dated 29/4/2025. As such, it appears that at this stage, the petitioner of Zimma petition number 240/25 did not have any ownership claim over the seized TMT bars. Under the above circumstances and having regard to the submission made by the learned counsel for the petitioner of Zimma petition number 240/25, the prayer for release of seized TMT bars to the custody of petitioner of Zimma petition number 240/25 dated 10/4/2025 stands rejected. Lordship, that's next page. The Zimma petition by the informant that was allowed. That order also I am challenging on. 5/5/2025, page 83C of my petition, Your Lordship. May I read? Learned APP is present for petitioner / informant of Zimma petition number 325/25 dated 2/5/2025. Report call from the IO is received. Peruse the report. As per the report, the owner of the seized 29 tons of TMT bar is the informant Sri Vidyut Sarkar. Further, the seized TMT bars are not required for further investigation. It is also mentioned that the investigation will not get hampered in any manner if the seized TMT bars are released to the custody of informant. Peruse the case record. In view of the above, the IO is directed to release the seized 29 tons of TMT bars to the custody of informant Sri Vidyut Sarkar upon execution of a bond of rupees such and such. The bond shall contain a condition that the informant shall produce the seized 29 tons TMT bars before this honorable court or before the IO as and when required in connection with this case. Your Lordship, now what has happened subsequent to the passing of this order, the informant, he has refused to take Zimma, Your Lordship. That is also reflected in the learned court's order, trial court's order. That is at the order sheet, Your Lordship will find at page 77. Page 77 of my petition. The IO subsequently filed a petition.
77.
Page 77. The subsequent to the issuance of the impugn order. Order dated 19/5/2025. May I read here? Case record is put up since the petition filed by the IO SI so-and-so of Nalbari PS stating that as per the order passed by the honorable court to get Zimma of 29 tons of iron rod to petitioner Vidyut Sarkar with a bond of rupees so-and-so, he followed the order. However, the original proprietor Sri Anupam Sharma, who is the owner of Anupam Nirmal Limited, vehemently denied to take Zimma of 29 tons of iron rod until the case is pending, and hence the IO has failed to prepare inventory of the 29 tons of TMT bars. The IO is present today. Heard, peruse the case record. Perusal of the case record reveals that Zimma petition number 240/25 dated 10/4/2025.
What is the case about?
Lordship, case was that the Sham Steel, they had sent a consignment of 32 ton of TMT bars to Anupam Private Limited. Now, during
It
transit,
erodes how? How it erodes?
FIR, Your Lordship, at page 33. This is an FIR dated 24/3/2025 before the officer in charge Nalbari Police Station. Sir, most respectfully, I humbly state that on 14/3/2025, Anupam Nirman Private Limited has bought from Sham Steel West Bengal 32 ton iron rod at rupees such and such for their company work to Musalpur, which was brought by the driver of the vehicle number so and so. On 22/3/2025, during the day at around 3:30 p.m., when the road was weighed at a weigh bridge located at Tihu Highway, 32 tons of rod was found therein. At around 5 p.m. in the evening, when the driver started towards Musalpur for unloading the vehicle at around 10:30 p.m. in the night, the rear tire of the said vehicle got stuck in a drain at Khatabari, Nalbari town. And we brought car lifting equipments of our company and sent the vehicle to Musalpur after lifting it. but we became suspicious as to how the vehicle got stuck at Nalbari instead of going to Musalpur. And as such, we called the driver to bring the vehicle to Tihu Weighbridge. And when the vehicle was again weighed at Tihu Weighbridge, 3 tons of rod was found to be in shortage. Thereafter, upon interrogating the driver said that while he was bringing the rod from West Bengal, after 40-50 kilometers, the owner of the said vehicle, Rahul Mishra, unloaded 3 tons of rod and placed sandbags weighing 3 tons in the secret chamber of the said vehicle. And after weighing at Tihu Weighbridge, the said sandbags were thrown in the road. Therefore, sir, the matter may be investigated and the stolen rod be recovered, and further necessary action may be taken again.
Who is this informant?
Chief
in charge.
informant is Vidyut Sarkar, is site in charge of Anupam Nirman Private Limited. On behalf of the company, he is the employee of the company. He has lost his FIR. Now, what has happened, Your Lordship? In lieu of the earlier consignment that was sent to Anupam Nirman by Shyam Steel, already another consignment was sent in lieu of that without taking any payment, Your Lordship. So, but in the trial
By
court,
which one?
I placed it, Your Lordship, at page 85. I have annexed it, purchase order, page 85. Already, this is a tax invoice, Lordship, PO number, such and such. PO
Whether this consignment has been received?
Yes, Your Lordship. In the next page, Your Lordship will find this was received and weighed also. Page 86. This is dated 17/4/25. Gross weight so and so on 17/4/25. Time in the morning 10 a.m. Then again in the evening it was weighed. So net weight this much, and
Gross weight is different, 45,000.
45,000
Okay, tar weight.
with load. And after unloading,
Net weight.
then net weight is this one.
Okay.
And this is the seal of the company in the
Okay.
right hand side
Hmm.
of the receiving. So
Hmm.
they have already received, Your Lordship, on 17/4 itself.
Hmm.
But in the trial court, there seems to have been some misunderstanding, Your Lordship. They have objected to our prayer for the Jimma of the consignment. In anyway, Your Lordship, this is not the subject matter of the case. The subject matter is only the 3 tons which were stolen, and that has not been recovered.
Hmm.
Now, because of that, this our property is stuck here, Your Lordship, since last 3 months. And Your Lordship, it has been kept in open.
But that fact that this subsequent dispatch
Yes.
of coal
Yes.
has been received by the informant or the Anupam Nirman,
Yes.
that is not brought on record nowhere.
That was argued, Your Lordship, but the document.
Argued, but
But the difficulty, Your Lordship,
how can the court rely on argument without
Document.
substance?
that was not produced. But
Then-
Your Lordship, once the learned trial court has rejected our application, the difficulty is if we pass, we cannot approach the court, learned court again under the code.
Then we have to reissue notice
Notice.
only, that's all. Part Mr. G.J. Ramil, Learned Counsel for the petition. And Ms. Sij Boral and additional public prosecutor. For response number 1, state of Assam. To stop. Essaying. Orders, dated 2/5/2025. Where is that 2/5/2025 order?
Page 83, Your Lordship, 83A.
Page 83. Within bracket capital A. And dated 5/5/2025. Within bracket 83 and again annex 10 capital A. And annex order dated 5/5/2025. Within bracket annex B. Passed by the Court of Learned Chief Judicial Magistrate. Nalbari. With regard to denial of custody, interim custody of TMT bars, weighing seized in connection with Nalbari Police Station. Case number 97/2025. The instant criminal petition is preferred to be issued notice returnable in 4 weeks as Ms. Bora has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Formal notice to the respondent number 1, State of Assam is not necessary. Post up. Extra copy. Within 3 working days, the petitioners shall take steps for service of notice upon the respondent number 2 and the respondent number 3 by registered post with AD as well as by usual process. Post up. The additional public prosecutor, the additional public prosecutor is to forward a copy of the writ petition along with the annexes thereto to the investigating officer of Nalbari Police Station, case number so and so as to obtain a report as regards the prayer made on behalf of the petitioner regarding interim custody of the material seized white seizure list dated
Page 39.
dated
Dated, Your Lordship, 24/3/2024.
in brackets MR number 59/2025.
Lordship, we may be permitted to take justice services.
In addition, justice service.
Much of.
The criminal division petition against the judgment and order dated 36/2025 passed in criminal appeal number 6/2024 by the learned additional session judge Kamrup, upholding and conviction and sentence by judgment and order dated 20/12/2023 passed in CR case number 3612C 2018 by the learned judicial magistrate first class Guwahati, whereby convicting and sentencing.
Concurrent finding.
Yes, ma'am.
Here. What is the ground?
Well, it's not a
No, what is the ground?
there is a contradictory.
Compliance
Contradiction, my lord.
of the
Too many
conditions.
No, my lord,
Check
not-
was issued by you.
my lord,
Check was issued by you
yes, my lord.
under your signature. What is the amount of the check?
6 lakhs, my lord.
Then thereafter it was dishonored for what reason?
Due to stop payment.
Stop payment.
Stop payment.
Thereafter notices were served.
Yes,
He received.
yes, my lord.
Did you reply?
Yes. No, no, no.
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 Then it was
I
submitted.
contested the
Complaint
case.
was filed within due time.
Yes.
How many witnesses were examined?
Two PWs examined, one with DW. One DW.
One DW.
Yes.
What the DW said?
DW complained himself. Petitioner himself, my lord.
So, was he successful in rebut the presumption?
I have stated my ground, my lord.
You have stated your ground.
The PW1 is clear and petitioner never approached the respondent on a
So what about section 148 of the NI Act?
compensation.
Yes. There is an appeal. In case of
Yes,
appeal,
power of appeal.
may
payment of
order
pending appeal.
the appellant to deposit such sum,
Yes, my lord.
which shall be minimum of 20%
20.
of the fine. Are you agreeable?
Okay, my lord. 25%, my lord.
25%, good enough.
Till my suspend my
Then you
They
will
will
suspend.
Yes, my lord.
Within what time?
The 30 days, my lord. From today, my lord.
We make it a fixed date, returnable. Today is
Today's
28.
20. Next 30.
Okay, 28 August.
20 August.
28 is Thursday, 29 August.
29.
Okay.
Can it? Can it be, my lord, 2, my lord?
Okay. September,
September 2.
1st of September.
1st of September. Nice.
Heard Mr. B. Burango. learned counsel for the petition, revision petition. And Miss S. H. Bora, learned edition, public prosecutor for the respondent number 1, State of Assam. Full stop. By this criminal revision petition, the petitioner has put to challenge a judgment dated 36/2025 passed by the Learned Additional Session Judge FTC number 3 Kamrup Metro Guwahati as an appellate court in criminal appeal number 06 of 2024, whereby the Learned Appellate Court has affirmed the judgment and order judgment dated 20/12/2023 passed by the Learned Trial Court of Judicial passed by the Court of Judicial Magistrate First Class Kamrup Metro Guwahati as a trial court in a complaint case, CR case number 3612 report small c 2018 first up. The courts have reached a concurrent finding of fact that the accused is guilty of an offense under Section 138 Negotiable Instrument Act. First up. The petitioner has been convicted accordingly and has been sentenced to pay a fine of rupees 7,50,000 in default of payment of the fine amount, to suffer simple imprisonment of another 2 months. Full stop. A number of contentions has been raised to assert the legality, propriety or correctness of the impugned judgments. Full stop. Issue notice returnable on 1st of September. A petitioner shall take steps for service of notice. As Ms. Bora, the petitioner shall take steps for service of notice upon the respondent number 2 by registered postal lady as well as by usual process within 3 working days from today. The land counsel for the parties are also heard on the point of deposits having regard to the provisions contained in Section 148 of the Negotiable Instrument Act. Full stop. The and on the interim period. Full stop. The having heard the land counsel for the parties, the it is ordered that the execution of the sentence passed against the petition shall remain suspended subject to a deposit of 25% of the fine amount before the registry of this court on or before the returnable date, 1/9/2025. First of pending it is further observed that the petition shall be allowed to be released on bail. Bail order is to on bail on fees, bail bond of rupees 20,000 with 1 surety with the satisfaction of the trial court. Subject to the condition of depositor?
My lord, he's already on bail, my lord, remain on previous bail, my lord. Maybe allowed, but.
Is it provided in revision? It is not there. It is not there.
My
I have seen.
Obliged, my lord. Obliged, I'll.
I don't mind.
Okay. Okay. State appeal on the prayer of Ms. S.H. Boral, Learned Counsel for the appellant states the case stands adjourned. For the day? For the day?
The date of.
For the day? 10/11, same.
I don't know what 12.
That's what I'm being.
Huh? You are the counsel.
No money.
You name.
Password for timing.
Item 13.
Hardin. So, for the time being or what? Okay.
Item 14.
May please. So here NBWA non-bailable warrant of arrest has been issued against the petitioner, madam. Subsequently, madam, proclamation has also been issued.
Proclamation
Yes, madam.
has been issued.
Yes, and after the execution of the proclamation, madam, the petitioner came to know about the initiation of the criminal proceedings, madam.
Yes, Mr. Burwa. 32.
32, that is the order of issuance of NBWA.
Oh, what is the offense first? FIR? FIR is what?
Allegation, madam, is theft
FIR,
of
FIR,
tires.
FIR.
Yes, page 15 is the translated copy, madam.
Base 15. 12-wheel truck. Registration was in the name of my brother, Kiwari. On friends of second party, Durlov Das. You were a driver?
My lord. Driver.
Guwahati Majuli. Theft of tires.
Tires.
Second party stolen 4 new tires. Okay. 30. Offense.
Offense 420 and 470.
379. Okay. Charge-sheeted.
Charge-sheeted.
When?
Charge-sheet at page 21, my lord.
21.
It
When?
was submitted.
31/1/2022.
Charge-sheet was submitted on 31/1/2021, page 24, my lord, that will be clear.
How can it be? It is beyond prior to FIR.
FIR
Not
was
be.
29/9/2020.
Then you have typed wrongly, page 15. That is the problem.
23/9/2020, my lord. Oh, yes.
That is a problem for me to rely upon your translation. Then what happens after submission of charge sheet?
Thereafter,
I have submitted a
summons-
charge sheet. Where is your charge sheet? Type copy?
type copy page 21, my lord.
Okay. Okay. So someone was issued initially.
Yes, ma'am. Summons were issued, madam. And on page 32, madam, 5/10/23, NBW was issued, madam.
BA to take steps appear summons issued issue phrase. issue phrase, summon. Someone issued not return with any report. Issued in the report, we issued a
Summons were served on
duly
the,
served. It was October 2023. Did not turn up. NBWA. NBWA. So someone were served.
served on the brother of the petitioner, my lord. My lord, he is a
So it is due service.
yes, yes, service is due, my lord.
Then
Only thing, my lord, will go and appear, my lord. NBW is suspended, my lord, will go and appear. But the next
NBW has returned and reports in the report. What is your explanation regarding non-appearance after some service?
well, the summons were served upon the brother of the petitioner, my lord, and the petitioner, he is a driver. He goes around places, my lord, but that the summon regarding the summons, my lord, that was not informed to the petitioner. He came to know about regarding the initiation of the criminal proceeding, my lord, only after execution of the proclamation, my lord.
Where is that?
My lord.
Proclamation?
Proclamation, my lord, that was issued order, my lord, page 37. NBW and proclamation.
Process of proclamation is not complete. Not complete?
Still issued, madam.
Not complete.
It was
There is a procedure to complete the process. Okay, then let him appear.
I submit, I upon submission, matter what trial court has committed illegality. Trial court has not committed any illegality.
No, trial court has not committed
illegality
illegality.
has not there.
He did not appear. Now, if we go on the process, this driver will go all over India, but he will not appear. Better to conclude the trial. Otherwise, the process. Heard Mr. P.K. Munil and counsel for the petitioner and Mr. R.J. Burwal and additional public prosecutor for the respondent state post of. The informant. One Ovilas Sharma as the informant lodged a first information report on 23/9/2020
21.
before the officer in charge Dhalpur police station against the petitioner as the accused, alleging theft of 4 new tires of a truck bearing registration number AS-01/JC-9391, which belonged to his brother, Sudhanshu Tiwari, page 15 of the sir. Full stop. The petitioner in the FIR, it was stated in the FIR that the petitioner was engaged as a driver of the said vehicle. Full stop. On the basis of the FIR, Vipuria Police Station, case number 382/2020, was registered on 24/9/2020 for the offences under section 420 and section 379, Indian Penal Code. After investigation, the case resulted in a charge sheet dated 31/1/2022. Finding a YFC case against the petitioner.
Charge sheet on 2021, man.
Again, this is also wrong.
No, man, page 24.
This is also wrong. Page 21. See the last date you have given.
Sorry, sir.
Charge dated 31/1/2021, finding a rational case against the petitioner for committing the offences under section 420 and 379 IPC. Post one. On submission of the charge sheet, the trial court of the judicial magistrate first class, Lakshmipur, not Lakshmipur, in ZR case number 2407 2020 within bracket PRC number 883/2020, which arose out of Bipuria Police Station case number 382/2020, issued summons. Initially issued summons provide order
Page 20.
dated 3/9/2020 and thereafter post up. A report was submitted before the learned trial court that the summons issued to the petition had returned after due service. Post up, it was on 5/10/2023, the trial court had issued bailable warrant of arrest, non-bailable warrant of arrest to secure the appearance of the petitioner for the trial, taking note of the service report of the summons. Post of the subsequent orders, trial court issued non-bailable warrant of arrest as the warrants were not executed. Post of it was on 5/6/2023, the learned trial court had observed that the accused was not found. As per the report of the inquiry officer, the accused was not found in the given address as he was at Arunachal Pradesh at the time. Post of with an observation that the accused has been absconding to avoid arrest, the learned trial court on 5/6/2025 issued proclamation against the petitioner along with NBWA. Post of Mr. Munil and counsel for the petitioner has submitted that the petitioner is a driver by occupation, and because of his nature of job, the petitioner does not ordinarily stay at his native place. Post of the summons which was stated to have been served, as per the report, was served upon the brother of the petitioner, and the petitioner had no knowledge about the summons as he did not receive the summons personally. Post of it was only after issuance of proclamation, the petitioner came to know about the pendency of ZR case number 2047/2020 before the trial court. Post of Mr. Munish and counsel for the petitioner has further submitted that the petitioner is ready and willing to participate in the trial. Post of the petitioner is, however, under the apprehension that before appearance of the petitioner before the learned trial court, the petitioner might be taken into custody by police for executing the warrant of arrest. Post of Mr. Burua, learned additional public prosecutor, has submitted that the petitioner has been avoiding the service of summons as well as execution of the warrants, meaning thereby, the petitioner is avoiding is an absconder, full stop. He has, however, submitted that if the petitioner participates in the trial, the same would facilitate an expeditious conclusion of the trial, full stop. The petitioner is facing possible charges for the offenses under section 420 IPC and section 379 IPC. First of the charges are yet to be framed. First of for an expeditious conclusion of the trial, the participation of the petitioner as the charge sheet accused is necessary. First of having considered the facts and circumstances obtaining in the case in its entirety, and for an expeditious conclusion of the trial, this court is of the considered view that since the petitioner is ready and willing to participate in the trial, the warrant of arrest issued against the petitioner by the line trial court can be kept in abeyance to facilitate the petitioner to appear before the line trial court within a stipulated time period. It is ordered accordingly. It is further ordered that petitioner shall appear before the line trial court within a period of 2 weeks from today. And if upon such appearance, the petitioner prefers any application seeking for his bail, the same shall be considered by the line trial court in accordance with law and on its own merit. It is further observed that in the event of failure on the part of the petitioner to appear within a period of 2 weeks from today, then the warrant of arrest issued earlier against the petitioner will stand revived. With the above observations and directions, the instant criminal petition is disposed of. No cost.
What's up?
Item 16.
Yeah, please allow.
Yes.
But this is a criminal petition, man,
Yes.
for quashing of a proceeding.
For quashing of a proceeding. What kind of proceeding?
Well, POSCO, my lord. 141/2024, my
What
lord.
is the FIR?
FIR, my lord, particular page number 17, my lord.
Vernacular page number 17.
Hello.
Correctly translated?
Translated page number 15, my lord. My lord, this is charge sheeted matter, my lord.
Let us see.
Main accused Raju is not petitioner here, my lord. Other two brothers are, my lord, are the petitioner here, my lord. They have been implicated, two brothers, my lord. And
Charge sheet
charge
under
sheeted, my lord.
how many? Rajibul Haq Raju,
Raju is not petitioner here, my lord.
Samad Ali Manik, Manan Ali. So 3 persons have been charge sheeted.
Charge sheeted, my lord.
What are the offenses?
Offenses, my lord, 126.
Let us see the charge sheets.
Page number 23, my lord.
Then it will come to page number 31.
31.
31 second paragraph.
Page number 20, my lord, medical report, my lord. Medical report is everything normal, my lord.
So on the basis of that, you are
My lord,
seeking quashing
my lord, two brothers cannot.
Let us
commit, my
see.
lord.
the statement. That will cleanse the issue.
He is already examined by the
Now, my lord, at this stage, I am not praying any interim, my lord. Just-
No, we are thinking of issuing notice or dismissal in limine. Question of interim will come later on.
Uh,
Whether to admit or not to admit, or whether to issue notice or not to issue notice. Interim will come on the second stage.
And, my lord, two brothers.
Statement has been, deposition has been recorded.
Recorded.
examined. May read the vernacular model. It started from another page.
What is the date of the offense as per the FIR?
24/8/2024.
Admittedly minor. Admittedly minor.
27/8.
And 164 and testimony found to be consistent on the material points.
My lord,
Why should we not
my
issue
lord,
notice?
164 statement, my lord. One line, my lord. I am reading, my lord. Moi baki lorad kejonon naam najanu. 143, my lord.
Obviously, if the person accused number 1 has stabbed the victim and thereafter invited 2 more,
My-
how can the lady know? This statement is at the immediately after recovery of the guard.
my- And informant also.
Oh, we are dismissing it in limine. This kind of petition is ill-advised. Looks like. Anything?
And my lord,
Medical report is not the final view. It is an opinion.
My-
Court has to
my lord,
decide whether petitioner is of sterling quality or not. That will be a matter of appreciation of the evidence. Trial has started.
my lord,
You have participated in the trial.
my lord, the petitioner here are the two brothers, my lord. Two brothers cannot commit, my lord, such and your lordship, my lord.
So one more will impose cost.
Two brothers, my lord.
Will impose cost. 164 statement, testimony is found to be consistent on material points. Obviously, this identification can only be made after apprehension of the accused. You confine her in a room. I should not say more. 13, but next time onwards, I'll dismiss this kind of petition. Heard Mr. F. L. Oscar, learned counsel for the petitions, and Mr. R.J. Burwal, learned additional public prosecutor for the respondent state post. After hearing the learned counsel for the petition parties at some length, Mr. Oscar, learned counsel for the petition has submitted that the petitions be granted the liberty to withdraw the criminal petition. Post in view of the above, Mr. Burwal, learned additional public prosecutor has submitted that the state has no objection if the prayer is allowed. Post in view of the above submission made by the Mr. Loskal and counsel for the petitioners, the criminal petition stands dismissed on withdrawal.
Obliged.
17.
May I please, your lordship.
Yes.
My lord, the criminal petition has been directed against the order dated 17/5/2025, my lord. Whereby my petition for recalling of witnesses was rejected,
Verificatory petition.
my lord.
When she was examined,
My lord,
24/5. So defense counsel was not prepared at that point of time.
my lord, what happened, her own statement in cross-examination.
That is a matter of appreciation, not a clarification
My lord,
by the trial court.
my lord.
Page 28 is your petition.
Yes, my lord.
Paragraph 2 is the relevant part.
Yes.
So this is not for just decision of the case. Second part of section 311. You have thoroughly examined? Some confusion?
Yes, my lord.
So where is the provision for further cross-examination when there is no re-examination?
My lord,
Law does not permit. 311, it is for the court for just decision of the case.
my lord.
And where is the
kindly-
court order?
Yes, my lord. My lord, kindly peruse the deposition, my lord.
Right. Hard, Mr. J. Soiki. Yes, anything? No point wasting time. 376, 4 POXO case. Where is the deposition of the lady?
22 make and leave.
I don't know what I think.
Your lordship. I am appearing on behalf of K. Bhattacharjee. Lordship, kindly matter may be adjourned for today.
What are they? On the pair of Miss
A. Burma.
A. Burman and counsel for the petition, the case is passport part of the.
Lordship, give a date.
Next week, Wednesday, it will be listed.
I don't know what 19.
May I please, lordship. The petition for quashing of FIR and charge sheet, my lord. My lord, kindly see page 31 to 33, my lord. Complainant and her husband amicably settled for separation, my lord. Whereby, my lord, the petitioner was the witness number 1. Then, my lord, and that amicable settlement settled on, my lord.
No, what kind of proceeding before the session judge?
My lord, I am coming, my lord.
Let us see.
That amicable settlement made execution on 18/7. And FIR laws, my lord, FIR means complaint laws before the lordship court. On
Due to quarrel with each other, the conjugal life has get to the person, but the father intend to separate from each other individually. This was executed when?
my lord,
18 July. No. What is the criminal case?
my lord, page FIR is page 12 to 22, my lord.
Is 12 to 22.
My lord, that was filed on 8/9/2024.
Who has filed? Wife.
After 2 months.
Wife has filed.
Wife, complainant wife. Wife means complainant victim, my lord. Filed the complaint before the honorable court, man. That was forwarded to the police station and registered as GR case.
What is the sum and substance of the complaint?
My lord, victim is the married wife having 4 numbers of children, my lord. And amicably settle separation between the husband and
No,
wife.
what is the FIR? What
FIR
is the
is
content
page-
of the FIR?
My lord, my lord. FIR is page 12 to 22, my lord. And page 12 to 22, my lord.
with due respect, may I read, my lord?
Who is the accused here?
Accused is the witness where put the signature in the judicial separation.
Sir, I could not understand.
Hardship, my lord, page number 28, well. It will make it clear.
Search series page 23 to 29. my lord.
28, my lord, that-
20.
Let me read it. Yes, Mr. Boro, what is this? What is the allegation?
The given portion, page number 29, my lord. 29, my lord. That's it. Sir, my lord, ঠিক, hard line. ঠিক ভাই, দুবছর আগতে এদিন আসামের জন্য জন্য ঘৰত কোরিয়ার স্বামী নমস্কাৰ
Okay, okay,
ঘৰত
okay. What are the offenses? 318.
My lord,
318.
allegation is, my lord, 318, sitting, criminal intimidation, punishment for death,
318.
extortion, sexual intercourse
Cheating.
with the employees, etc. my lord.
15. And
And the same,
351.
and the same
Intimidation.
are stated also.
64. Rape. 308. Extortion. Yes. FIR has been lodged and thereafter charge sheet has been submitted.
Charge sheet submitted.
Right.
And the same is on the same allegation, charge sheet has been also submitted. my lord. And thereafter, my lord, that matter come to, committed to the district and session judge.
Yes.
And that was fixed on 2/8 for consideration of sub. my lord. Now, my lord, my humble submission, my lord, I am only the witness, my lord, in the judicial separation of the victim and her husband. That was, my lord, executed on, my lord, 18/7.
Moizuddin.
My lord, yes, my lord. Witness number 1.
In the charge sheet. Or what?
My lord, that is amicable separation between the husband and wife of the victim and husband. Husband's name is, my lord, Khale Galin, and victim name is the Asfal Bibi,
Moizuddin.
who is 35 years old.
18 July.
And after 2 months, my lord, a complaint has been filed before the honorable court. That
This
was,
is subsequent,
my lord, that was later on.
18 July compromise, but the lady has alleged all these things against you.
Against me, madam. Yes, madam.
How does that, you're witnessing the mutual separation?
No. Judicial happened between the husband and Abdul Khalik and Asfal. Asfal, they are the husband and wife. I was the only the witness.
Okay, if you have a good case, then you go for discharge.
And in this regard, my lord,
Charge is yet to be framed. Yes, you appear and contest the case. Go for discharge, file and discharge application.
only the petitioner came, my lord. If the trial has been going, then it will be a long time.
What is the provision for discharge?
The petitioner, he
Mister, you have not been able to project your case.
as being the innocent man, honest.
Case was committed. Case was committed.
Case is committed to the district session judge.
So at the stage of committal, you were there.
And if he fixed on.
You were there at the stage of committal.
Well,
Where are the documents given to you under 207?
Page 30, my lord. Order is there.
Mr. Borua, make him understand. We don't know additional documents. He appeared in at the stage of 207. Now it is what?
Below the page.
All the copies are with him. Is it not?
My uncle at this stage notice make a letter.
No, notice will-
Later on, I will fairly submit.
To send a notice, we have to satisfy ourselves. You appeared at the committal stage. Where are the documents?
Charges come, my lord, then he can again come.
Obviously, if he is not interested, we have to decide this.
Can file for application for discharge.
Right. He is not availing that. He is preferring to invoke the inherent jurisdiction. Now, he has appeared at the stage of 207, now 230. All the copies are with him. It is not annexed.
My lord, all those copies would furnish, negative fixed.
We don't know what are the documents.
My lord, whatever may be, my colleague.
If those allegations made therein are accepted to be true, whether the charge is still.
Include all documents, my lord.
Better. You bring.
After.
Mr. B. Islam Learned Counsel for the petition has submitted that the copies furnished to the petition at the stage of section 230 BNSS will be brought on record by way of an additional affidavit to establish the case after it.
Item number 20.
May it please your lordship. This is the second time we have before this honorable court seeking Jimma of a court. My lord, your lordship will find the scissor list first. Your lordship will look at page 44. Wait a minute. Initially, we came for page 44 is the scissor list. We came for 6 item. Sorry. Page 44, your lordship will kindly take note. We came for Lekhapani PS case number 32 of 2024 under section 379. This amount number 36. And we came for serial number 6 at page 45. This your lordship will say now we are coming for serial number 6. Earlier we came for Lekhapani PS case number 35. Your lordship will find the order of this honorable court at page. Just a moment, I'm taking your lordship directly to the order. 271. Court 271 to 8. High Court order. The High Court order is at my lord page 273. The operative portion is at 278. Last paragraph. Your lordship got page 278.
Yes.
Now your lordship will see the page 278, paragraph number 11. Accordingly, the orders passed by the learned trial court on 4/10/2024 and 27/9/2024, whereby the prayer for Jimma was rejected and respondent number 2 was granted Jimma along with permission to sell the seized coal. Respondent number 2 is the geology department, my lord. Coal at auction respectively need to be reconsidered. Considering the submission of the learned counsels for both sides and the fact that the petitioner has produced all relevant documents proving that he is the genuine purchaser of the seized coal, it is directed that the petitioner shall appear before the learned court below and file a petition for Jimma. The learned court shall consider the petition in accordance with law. Further, the learned trial court shall be at liberty to fix the amount of indemnity bond before granting Jimma of the said coal to the petitioner, considering the value of the coal. Then we appear before the trial court. That order is at page 279.
What this court has held?
Well, court ultimately
14,
direct,
2000
to approach the trial court for Jimma, and the trial court will
are
fix the indemnity.
reconsidered.
Yes. Then court,
Reconsidered.
yes, then your lordship will, because by the earlier order of the trial court, the Jimma of the coal was given to the geology department, but we showed to the court that these are the documents that we have purchased the coal. That's why the matter was remanded to the trial court again to re-examine. The trial court order is at next page, at page 279, Annexure 13. First paragraph, your lordship talks about the order of the court. Then your lordship will find at page 280 the operative portion. And your lordship will take note that this order at page 279 has been passed in connection with Lekhapani PS case number 35 of 2024, which is now being challenged. So this 35 order, your lordship will say, see, the High Court order, terms of High Court order, the IO is directed to give Jimma of the seized coal to his lawful owner after ascertaining the identity of the actual owner and verification of the original documents on receiving a bond which is equivalent to the market price of the said coal. Thus, the Jimma petition number so and so is disposed of accordingly. Now, when we went to the depot, the depot which I had taken on rent, it was sealed. In terms of the order, my lord, the coal which was lying outside the depot, because on the boundary wall outside the gate, that they have given in custody to us in terms of Lekhapani PS case number 35. The IO says that although the coal inside the gate is in connection with Lekhapani PS case number 32 of 2025, it can't be granted custody. So we again filed an application before the learned trial court, that is at page 281. We filed the application seeking the Jimma of the coal which is lying inside in terms of section 497 of BNSS, which is earlier it was 451 CPC. Now, of course, we have a time frame under 497, unlike in 451. Your lordship will find the report of the IO is at page 280, madam. 280, sorry. Report of the IO, your lordship may kindly say, in connection with Lekhapani PS case number 32 of 2024, which we are concerned now, madam. Carry everything. Your Lordship, may kindly see page 288. The report of the IO in connection with the present case which we are seeking custody of the coal matter. Page 288. Your Lordship.
No, if we read this order at page 286,
Yes.
IO says in his report
Yes, ma'am.
that on 27/9/2024,
Yes, ma'am.
Jima or custody was given
Yes.
to the geology director.
Just like in earlier. Okay.
Right.
Yes.
That in between page 286,
Yes, ma'am.
consequently the coal has been auctioned.
Yes, ma'am. Just like in earlier occasion also, madam. Now.
No,
although
was
it
auctioned.
Yes, madam. Although it is auction, no, till date, nobody has taken custody of the coal.
No, question is if it is auction, there was a bidder.
No, madam. No.
How can it be?
But it is not there.
No, I have seen this order.
Your Lordship,
Mr.
that's why. No,
I have seen the High Court order.
Yes.
Whatever may be, but question is it was to be reconsidered.
Yes.
This order,
Yes.
Mr.
Yes.
There are some inherent thing
Yes.
that it is to be reconsidered. Otherwise, earlier, once an order is passed under section 382, 362 CRPC, I don't know the equivalent provision.
Yes, ma'am. Even me, I now have to open the book. Some.
Yes, I have problem with that.
Yes.
But
We all.
under section 362 CRPC, once a court has passed an order, that court loses the jurisdiction to reconsider its order. There is no review, unlike in CPC, in CRPC.
Yes, ma'am.
That our High Court order is for reconsideration, which is something.
Ultimately, my lord, under 482, that order was passed under inherent jurisdiction of this court under 482, my lord.
But what is, it has to, or ought to have been?
It has to be, it has.
Ought to have been, ought to have been.
Fresh.
Ought to have been.
Yes, ma'am. But
anyway, page 286, if it is auctioned.
Yes, ma'am.
The coal has been auctioned.
Yes, ma'am.
Then there is a creation of no. How can it be?
Your Lordship will that's why your Lordship will see the report of the IO at page 288 first before we go to the order. With 288, your Lordship has gone it. With reference to the above mentioned subject, I have the honor to report that in connection with the aforementioned case, approximately 101,445.26 cubic meters of coal were seized from the land of Bisto Sema, Nitobe Sema, Pekai Sema, and they are the landowners of that Lal Pahar Pathargam. Now, your Lordship will see the next line, which is very important. During the investigation, it was discovered that the coal was stored by Mohammad Tajib, the present petitioner. Despite multiple attempts to collect documents regarding the storage of coal, no documents were found and no one claimed the coal at the police station. Consequently, the coal was auctioned through the Director of Geology and Mining and the auction documents are enclosed. The main gate was sealed by the executive magistrate Margeta and it will be open soon. As per the Honorable High Court's order dated November 11, 2024, a Jimma order was passed only for Lekhapane PS case number 35 of 2024 and no such order has been received in connection with the above reference case submitted for favor of your kind.
So what is the correctness of this statement? The coal has been auctioned through Directorate of
Nobody
Geology.
knows that whether the coal is auctioned or not. It is still
Auction documents are enclosed.
Well, what type subject to your Lordship?
Because if it is auctioned,
yes,
there is already another
yes. That's why your Lordship may record my statement. As on date, the gate is still closed. The coal is lying inside. I'm only till the next date, your Lordship will call for the report and all the documents from the LCA. But till the next date, status quo as on today shall be maintained. If it has not been given, that is the humble prayer. Yes, yes.
It clearly speaks that it was discovered that my coal has been given to the directors of minus geology and mining. After that, when consequently coal was and some documents are included. It is very much clear. In earlier order, pointed out, madam, reconsider parties.
No, no, order.
Yeah, so interim order may be passed, right? The order.
This order also says auction documents
Yes.
enclosed along with the report submitted by the IO.
So I'm not asking for stay of this order. I'm only praying before this honorable court that your lordship will give a short date to them. Till that time, status quo will be maintained, because after filing this, if they remove the coal, I'll have no right. If third party rights is created, then we can file an application, additional affidavit, making him a party to this litigation matter.
Yes, Mr. Usama. That appears to be reasonable.
Not-
Status quo means if by the auction,
Yes.
somebody has become the owner of the auction property, he will remain like that.
It may be like that, but I think,
You are party to it. You are party to it.
so by the,
For reconsideration of the earlier order, you are party to it.
who has been the director of jail, this case has to be heard.
Yes, yes. Everybody has to be heard, including if
plus
third
this-
party right has created.
Plus,
yes.
these auction documents need to be placed before this court. Auction documents need to be placed. Because then there is a provision for recompense.
Yes, ma'am. But
Whatever
that's why-
auction price,
Yeah, that's why
whatever auction price the auction has fetched, you will be a claimant for that.
Yes, that's why I'm not praying that you stay only status quo till the next day. My learned friend will not be prejudiced. My learned friend is not holding the brief for the geology department, neither he is holding the brief for the auctioneer. He is the state, and the state has.
Yes,
said
miss,
that-
let him say.
Now the auction procedure has been
Abo.
started now. So we do not know what is this.
Auction procedure, auction has been completed, I think.
Your lordship will see, your lordship will record my statement. This Jimma was granted on 27/9/2024. Even now in
Let us see 27/9/2024
Yes,
order.
that's why 27/9/2024 grant
Where is the order?
at page 289 that is reflected.
No. 27/9/2024. Where is the order?
Sir, just a moment, madam. 289.
No,
Just a moment, I'll check.
that is a report only.
Yes, no.
Okay, this is one.
288 is the report, 289 is the order.
Today is the date for compliance report, Jimma petition.
Page 291, the minor first statement. Thereafter, minor 10/7 order has been filed. Page.
Oh, let us see 27/9/2024.
Yes, ma'am.
This is at page 289. Your lordship will find the operative portion at 290. On such perusal, it appears that the IO of the instant case earlier prayed for Jimma of the coal given to NACF CIL Margeta. However, even after the prayer being allowed by the court, the IO could not hand over the coal to CIL due to problem in transport facility. Since the seized coal is lying unattended. So I am praying that today that whatever has had. But today I am praying that status quo till the net date. It will cause no prejudice to any of the party. Even after this order, nobody has transported the coal out of my premises. To that extent, your lordship may record my statement. Put this to statement to petitioner. This statement to the and your lordship will look my statement at page 14, ground number 5.
That is 27/9/2024.
Yes.
Jimma was given all the seized coal
Yes.
were given in custody of the Directorate of Geology,
Yes.
right?
And they said
And they were permitted also
to carry out
by
auction.
that order to sell through auction and deposit the amount in the government treasury
Yes.
after keeping a sample.
Yes.
Then when did you start moving your application? October.
Yes. after the order of the High Court, because then only we came to know that the
That was
inside
in respect of case number
35.
35.
Yes.
We are dealing with 32.
32. And after we have made a space, nearly a year has passed since then, and yet the petitioner's business premises remain sealed and locked with the coal lying
And we
there.
have to accept this that this has been auctioned already, unless rebutted specifically.
That's why I'm praying, my lord, that if it has been
If the
gone and the IO has submitted that due to lack of transport facilities, it has not been transported, your lordship will wait for a report till the next date. I'm not asking to reverse those orders. Only I'm praying that status quo as on date shall be maintained by the parties till the next date, my lord. Your lordship can have it as per your lordship's convenience, my lord. I don't have any objection to the date.
Heard, Mr. B.D. Paul.
291 pages. First, my report was called for here allowed auction.
That I have seen already. I have
Yes.
myself read it
Yes.
loudly.
Yes, thereafter, my lord,
A report IO says it has been already been auctioned.
yes, thereafter.
Auction documents are enclosed herewith.
Yeah.
Meaning thereby, if there was a bidder,
Yes.
he became the owner of the coal, which is a subject matter of case number 35. The coal is still lying there.
Whether it is lying there or.
That I don't know. He, Mr. Kumar is making a statement.
Been done, my lord. My lord, auction, my lord, one has to.
But the most prominent thing is that the auction documents are not part of this petition, not part of the IO report.
Yes.
At least it is not brought on record. We don't know
Yes.
whether there was a bidder and thereafter he became the successful bidder.
Because I pray for at least we call for the report, man. That you may consider the.
What status quo order will change the situation? Tell me. An order of status quo. He will not become a non-owner. He will remain an owner. He will remain as the auction purchaser. Complication will arise only for the petitioner.
He also party.
Unless auction process is set aside, petitioner cannot claim that.
Will be entitled for the money of the auction. Because
Money
the IO
realized we will know, we can close the proceeding.
Yes, my lord. IO has said that it was
That
discovered.
will be at the end of the trial.
Yes.
At this stage, my lord, if the report is called for, whether because of the fact that person has worked.
If he brings a report, we'll make him a party in this case. What's the problem?
Okay, you bring up then my Monday, you bring the report of the IO, which was submitted before the trial court. Okay, then we'll consider. If he is so otherwise, this only we need the only the report.
We have to be, my lord, we have to be practical, my lord. Your
We are also practical.
Yes, my lord. My learned
If
friend-
the report document indicates that auction process is complete
Yes.
and there is an owner
Yes, my lord.
of the coal now.
Yes, my lord.
And if the auction process is valid, okay.
Yes.
Or if the auction process, if you find from the report
Yes.
that auction process was not validly conducted,
Yes.
then you will have another option
Yes.
to challenge the auction process.
Yes, ma'am.
Then to set it aside.
Yes, ma'am. I'm aware of it. I'm obliged to your lordship. But your lordship will kindly say, is my prayer so unreasonable that if I ask for an order of status quo, will it change the character of any of this statement? No.
Okay, let us have the report. Till then, status quo be maintained.
Yes. Obliged, sir.
Monday. Next Monday. Report is already ready. You have only to get the report from the IO.
Yes.
That's all.
Okay.
Okay.
Consider this.
Yes, till then. That will shorten the process.
Yes, ma'am.
If there is an auction purchaser already, he has validly made it the bid and auction process is complete. End of the matter.
Not complete, then again, but that will be.
There will be different complication.
Then different
Heard.
complication.
Mr. B.D. Kaul, Senior Counsel, assisted by Mr. H. Chowgal, Counsel for the petitioner, and Mr. MP Gusamil, and Additional Public Prosecutor for the respondent number
1.
One. State also. Yes, any standing counsel?
I don't think so, my lord. We'll take step by tomorrow.
We are not issuing notice.
As your lordship pleases, let the report come, then your lordship will decide.
The subject matter of the instant criminal petition is the quantity of coal weighing 1145.26 cubic meter. Post up. Comma seized right. A seizure list, comma MR number 36/2024. Post up. It is submitted at about at the seized coal is subject matter of investigation of
The company PS case number 32 of 2024.
32 or 35?
32.
No, earlier case?
35.
Okay. 32 or 2020. Post up. On a claim for custody of the said seized coal, interim custody was made before the Court of Learned Judicial Magistrate First Class Margate, provide petition number 305/2025, comma, basically rejected.
Yes.
The claim of the petitioner was rejected by an order dated 10/7/2025 on the basis of a report of the IO report dated 10/7/2025. Post up. As per the report of the IO, comma, the seized coal was initially handed over to the Directorate of Geology and Mining with a liberty to get the seized coal auctioned and to deposit the sale proceeds to the state exchequer. Post up. As per the report of the IO, comma, the seized coal has already been auctioned and the auction documents were stated to be enclosed with the report. Post up. As the auction documents are not available, are not made available, comma, Mr. Goswami, Learned Additional Public Prosecutor, has submitted that he will obtain the full copy of the report dated 10/7/2025, submitted by the IO of Lakapani Police Station, case number 32 of 2024, before this court on Monday. Post up. Mr. Agrawal, Learned Conservator Petitioner, shall furnish an extra copy of the criminal petition along with annexed to Mr. Goswami by tomorrow. Post up. Lays the case on so and so. Till then, comma, the status quo as regards the status quo obtaining as regards the seized coal as on date, comma, is to be maintained.
Yeah, bless you.
Correction, auction process by instigated by my director.
I'm
But
saying-
he say-
No, no,
he
it
say
is part of the
my lord-
report. Also.
my lord, notice
What?
as of-
Full report of the IO, I said. Full report of the IO. Whether it really contains the auction documents or not.
That part,
He may have misunderstood. He may have misunderstood that auction is complete.
We are blessed.
Monday, owner remains owner, petitioner remains non-owner. Coal is under seal condition. What will be changed?
my
Heaven is not going to fall till Monday.
We are obliged.
Unnecessary objection not required to be made. Mr. Kumar has gone out satisfied with an innocuous order. Next.
Well, earlier, when our seniors used to make a argument, they will always look backside to see whether they are backside is approving or not. Nowadays, we have an advantage like that. This is a rare view mirror where we can see the council reaction on the back and we can look into the court and make our submission.
Okay, next.
We are blessed.
Item 21, alright.
Please, Your Lordship. Lordship, this
Yes.
petition is for quashing of a complaint case, Your Lordship, which is basically a civil dispute. The complainants here is a company and all the directors of the company. A criminal case has been filed under section 406, 420 and other sections, Your Lordship, stating that they have received certain amount as an advance and they have not submitted the document. They have not released the document.
Where is the order taking cognizance?
Lordship, that is not here. We have just received the summon. Just received the summon without a copy of the complaint. We have obtained the certified
Where is
copy.
the summons, sir?
Lordship, that is also
Nothing.
different. The CR.
Neither the order taking cognizance nor the summons.
Lordship, page 30 is the CR case, Your Lordship.
You get it on record.
Lordship, we'll file an
On the
addition.
prayer of Mr. DJ Mukherjee, Land Council for the petition and list the case on next Monday.
22.
Wait, please, Your Lordship. This was a limited prayer, my lord. This is a case under the SC and ST Act, my lord.
SC and ST Act.
My father and I were charge sheeted. Subsequently, one thing which has happened is that as Your Lordship knows, the special court is to take cognizance of the offences under the SC and the ST Act. Here, CJM took cognizance, my lord. Subsequently, processes were issued. I was initially absent with steps. Thereafter, I shifted to Tinsukia.
Where is the charge sheet?
Charge sheet, Your Lordship will find at page 20, my lord.
Page 20.
20, my lord. I am Mukul Sharma, my lord. My father is
Type copy.
type copy, my lord. It starts at page 19, my lord.
Have done.
And only this, because you are only challenged only on the point of, my lord, warrant of arrest, my lord, not on the merit of the case. Your Lordship will kindly see page
Investigating
23.
officer. Solicited to the was related to me. Cognizance is taken against the accused person.
CJM takes cognizance, my lord.
But that is not the ground of challenge.
No, my lord. I'm just
You
pointing it
say-
out, my lord. And then warrant is also the first instance. Warrant is also issued by the
When?
CJM, my lord. That is at page 28, my lord. Type copy, my lord. Till 1722, my lord, representation was there. On 1922, my lord.
Oh,
On the
which
first
steps?
Yes, on first with steps, then my lord without steps. Because I have given my explanation.
Since how long you started?
Since this is from 2022, my lord.
More than 1.5 years you were absent without
Without
steps?
steps.
With steps.
Initially, my lord, then without steps. I shifted to Tinsukia, my lord, and my father,
But you were aware.
I was aware, my lord.
You were aware of the
Petition
proceeding.
is there on, my default is there on my part, my lord. I do not deny that part. But at this and subsequently, my lord, PNA was issued and I was declared a proclaimed offender and the
Oh,
case
proclaim offender also.
and case has been filed, my lord. Now I intend to appear, my lord, and contest the case, my lord. So there's a pending warrant, my lord. If that is suspended, my lord, I will appear and contest the case.
And you
That
have-
order is at page 48, my lord.
You have prolonged the case of the complainant.
Yes, my lord. Default is there on my part, my lord.
No.
I do not deny that part, my lord. Default is there, my lord.
You have prolonged the case of the complainant who has alleged atrocities against you.
My lord.
Privacy case is found
Yes,
against you.
Yes, my lord. That part I am not denying.
We are awarding cost.
My lord will kindly appreciate, my lord, this person's
We will
father.
be awarding cost to be disbursed to the complainant.
My lord, I will appear, my lord. Court
You
will
appear.
decide, court will decide whether to take me into
But you have
custody.
prolonged the trial,
My lord, I have
despite being aware.
my lord, I have given my explanation for that, my lord.
Whatever, but 19/2022, thereafter no explanation will
Yes. So my
satisfy.
humble prayer for your lordship is that, my lord, at this stage, I only intend to go. If the trial court is not satisfied with my explanation, my lord, trial court will reject it. But considering that there is a
But
pending.
you have made the complainant to wait.
My Hello, the trial court may consider that aspect also while
No,
deciding.
this court is considering that aspect.
Hello.
Expressly apparent from the record.
But I can only pray, my lord, that my liberally, my lord, this.
NBW will be kept under suspension subject to deposit of a cost of rupees 10,000 to the complaint.
It may be reduced, my lord.
No, 10,000.
5,000, my lord.
3.5 years is too long a period.
My lord, 5,000 cost, my lord.
No,
This
10,000.
person, my lord, he.
Then 15.
No, my lord.
Don't make it a negotiable
My lord. I leave it to your
market.
lordship. I leave it to your lordship, my lord.
Yes, Mr. Goswami.
On the other case partner,
Complaint is to be compensated.
the claim of an
He is waiting for his deposition for last 3.5 years. And they are absent with steps for 1.5 years. Thereafter, NBW resulted. We are not touching upon proclamation.
Proclamation has already been executed. So there is only.
So executed, it is under attachment.
Yes, my lord. The only thing is, my lord, now a warrant. Yep.
Okay.
Very consider.
Where is the next date?
Next date, my lord, is on. So as far as I am concerned, my lord, case has been filed against me, my lord.
Oh, filed.
Filed against me.
August.
15 days, my lord, I'll okay. 10 days. Thank you.
You appear on 11th of August.
My lord.
Yes, Mr. Goswami. Try to get yourself independent before Independence Day. Heart, Mr. S. Nawaz, Learned Counsel for the petitioners. How many petitions?
Single petitioner, my lord.
Who is he? What is his name? Mukul Sharma.
Mukul Sharma, son, my lord.
What about father?
Father got arrested, my lord, but he was 100 years old, so he was released on bail the next.
100 years old.
That is on record.
Rupen Sharma.
Rupen Sharma.
Okay.
That is at page 46.
46.
46. His bail order, my lord. Sorry, man. Bail order is at 39, my lord. Born on 28/7/1926.
And Mr. MP Goswami. Right. Additional public prosecutor for the respond number 1, State of Assam. Having regard to the issue involved in this raised in this criminal petition filed under section 528 Bharatiya Nagorik Suraksha Honda 2023, the petition is taken up for disposal at the motion stage itself, dispensing with the process of issuing notice to the respondent number 2, that's complainant. Full stop. The facts, in brief, leading to the filing of the criminal petition can be stated at first, full stop. The first information report was lodged by the respondent number 2 as the informant, along with 3 other persons against the petitioner and his father as the accused persons, and the said FIR has been registered as Nongao Hodor Police Station case number 556/2018. For the offenses under section 294 and section 506 of the Indian Penal Code, read with section 27 of the Arms Act. after completion of investigation, the IO submitted a charge sheet in connection with Naga Hodor Police Station case number 556 of 2018. Finding a privacy case against the petitioner and his father, Rupen Sharma. For the offenses under sections 294/506/34 Indian Penal Code, read with section 3 within bracket X of the Scheduled Caste and Scheduled Tribes within bracket Prevention of Atrocities bracket close Act 1989 within bracket SC/ST Act. So on submission of the charge sheet, PRC case number 1024/2021 was registered and filed an order dated 20/03/2021, cognizance of the offenses, aforestated offenses were taken and issued process in the form of summons to the petitioners for their appearance to stand in the trial. Full stop. The learned trial court. No, sorry. The Court of Learned Chief Judicial Magistrate, Nagaon, continued to issue process within a summons up to
27/10/21.
27/10/2021.
21.
And during that period, the accused persons were absent with steps before the state court. Full stop.
Well, which steps? Someone still 27/10/21.
27/10/21.
21, my lord. Then summons, which steps still 17/22. 25.
7/10/2021. Full stop. On and from 21/2/2022, the accused persons were absent with steps before the state court by filing petitions. Full stop.
Page 28.
When on 14/12/2022, the accused persons were found absent without any steps, the Darling Court issued non-bailable warrant of arrest.
May I correct?
Sorry.
19/22, my lord.
19/2022. Full stop. The father of the petitioner was
Arrested on 15/2/24.
15/2/2024 in execution of the NBWA. Full stop. However, the warrant issued against the petitioner could not be executed during the subsequent period. Full stop. The father of the petitioner was allowed to go on bail on 15/2/2024.
16/2.
16/2/2024. Having regard to his age of 97 years and illness suffered by him. Full stop. The learned court, after issuing an order of proclamation and attachment along with NBWA comma, had reached the satisfaction or receipt of a report from the EU that the procedures for execution of P and A has been duly followed, full stop, by an order dated 12/3/2025, comma, the learned court, on the basis of the report of the EU and his statement given before the court, comma, filed the case, has filed a case while keeping the NBWA open for execution, full stop. Para. This petition has been preferred. Seeking, setting aside and quashing of the impin orders. Prayer head is Christian. Para. Mr. Nawaz, Learned Counsel for the petitioner submitted that the petitioner is ready and willing to appear before the Court of Learned Chief Judicial Magistrate.
No, it will be session judge now because subsequently CJM realized that wrongly cognizance was taken.
Okay.
That order is it?
Okay. Has submitted that the present at present, comma, the trial. Sorry, submission by order dated.
Page 32, member 1620.
By order dated 12/3/2025, comma, the everything is changing.
No, member, it is
One minute. Let me handle it. The trial of, sorry, the on submission of the charge sheet, comma, the case has finally been registered as special within bracket SC-ST bracket close case number 01/2023 before the Special Court, Nagaon, Assam. Full stop. By order dated by the above referred order dated 12/3/2025, comma, the Learned Special Court split up the case record for the other accused, comma, Rupen Sharma, while ordering filing of the case against the present petitioner. Full stop. The case is at the stage of consideration of the charges against the charge sheeted against the other charge sheeted accused person, comma, Rupen Sharma, and for production of the petitioner who has been declared as a proclaimed offender. Full stop. Para. By this petition, comma, the petitioner has averred that he is ready and willing to face the trials of special SC/ST case number 01/01 within bracket N, stroke 2023 before the learned special court also, but because of the warrant of arrest and he has proclaimed offender status. The petitioner is in apprehension of being taken into custody before his such appearance before the learned special court. Post of para. Mr. Gusami, learned additional public prosecutor appearing for the respondent number 1 state of Assam has submitted that the petitioner as a petitioner was well aware of the pendency of the case as far back as in the year 2021 or 22.
Steps, my lord. 22.
Which steps?
22, my lord.
22. As summons issued by the court were duly served upon him. So yet, due to his not appearance, the trial of the case got prolonged, has become protracted. Post of para. As the petitioner, along with the other charge-sheeted accused, who is incidentally his father, the petitioner's father, are likely to face the charges under the relevant provisions of the SC/ST Act and the Indian Penal Code. Are likely to face charges. So, though the charges are yet to be framed against the accused person because of his status as a proclaimed offender. It can be noticed. It is obvious that after submission of the charge sheet, the complainants, foreign number, are waiting for expeditious conclusion of the trial. The trial has become a protracted one due to apparent deliberate action on the part of the petitioner to appear before the court concerned, jurisdictional court. It can be easily noticed that more than a trial has become delayed for about 3 years. This court is also of the considered view that an expeditious trial is of utmost consideration, and to facilitate such expeditious conclusion of the trial, appearance of both the charge-sheeted accused persons are necessary. So at the same time, the complainants have been made waiting to depose before the court for about 3.5 years. Having regard to all this, all the above factors, this court is of considered view that since the petitioner is ready and willing, has undertaken to appear before the special court within on or before, what is the date I
11th of August.
proposed?
11th of
11.
August.
On 11/8/2025. The next date of the trial?
No, my lord, because
No.
as far as I'm
Okay,
concerned, it's fine.
11/2025. Come on. Let's go for facilitation of an expeditious trial. Deems it fit to keep the warrant of arrest NBWA issued against the petition under suspension till date. Post of. Subject to deposit of an amount of rupees 10,000 by the petitioner before the land special court on such appearance. Post of. In the event, the petition appears before the land special court on 11/8/2025 with an application for
On or before,
bail.
my lord, we'll try to, on or before, my lord, we'll try to appear before that.
On or before query, on or before, with an application for bail, the London Special Court shall consider the said application for bail in accordance with law and its own merits. Post of. On deposit, in the event of deposit of the cost of rupees 10,000, the London Special Court shall disburse the said amount to the complainants. With the above observations, with the observations and directions given above, the criminal petition is disposed of.
Deeply observed.
Again, 23.
May I please lordship? Your Honor, the present petition is filed under section 528 of Your Honor Bharatiya Nagarik Suraksha Sanhita, Your Honor, for quashing of FIR, Your Honor, lodged in Borlumuk police case, Your Honor, PS case number 344/18, Your Honor. Under section 294, 507, 509, 120B of Indian Penal Code and under section 67A of Information Technology Act 2000, Your Honor.
Where is the fire?
Yes, Your Honor.
Where is the fire?
Your Honor, page number 22, Your Honor. 29, Your Honor.
26.
26 is the typed copy, Your Honor. Annexer 4, Your Honor. You know, in the said FIR, Your Honor, the respondent number 2, lodged by respondent number 2, who filed that FIR, Your Honor, on his official capacity, Your Honor, ACP Jalukbari, Your Honor. In the said FIR, it is stated that I would like to initiate you that one abusive message targeting my daughter and me has come to my mobile number 94357-19835 from the mobile number 91014-45589. The screenshot of message is being enclosed herewith. The message is intimidating to me and it is being done with criminal conspiracy. The date of delivery of aforesaid message on WhatsApp is 24/4/2018.
What is this page 31? Why division match WBC?
Yes, Your Honor. Lordship, sorry. Your Honor, this is the order of Honorable High Court, Your Honor.
What is the purpose of preparing the petition?
Your Honor, actually, in connection with
It is a
the
separate issue.
yes, Your
It's
Honor,
a
separate
separate
issue.
That is a separate issue.
Yes, Your Honor.
So what is the
Lordship.
reason for seeking quashing of this affair?
Your Honor, the fact is that
He has
Your
given some facts,
yes, Your Honor.
which needs investigation.
Lordship.
Privacy allegations
Yes.
are to be accepted as true.
No, Your Honor. Your Honor, the
He has made allegations.
yes, Your
What
Honor.
what is the parameters for quashing an FIR?
Your Honor, the fact is that
What is
before
92 supplementary SCC 435?
Your Honor, prima facie case, yes, Your Honor. But Your Honor, the
What
fact
is the parameters? 1, 2, 3, 4, 5, 6, 7.
yes, and I cannot recall it as of now, Your Honor. But
If
you know,
don't
one
recall 1992 supplementary SCC, then what do you recall?
but the
What are the parameters for quashing an FIR? The decision I have cited That has attained the status of locus classicus,
Yes, your lordship.
right?
Yes,
Right.
your lord.
Kesavananda Bharati.
Right.
When we read this, and allegations at the stage of lodging the FIR are accepted to be true. And if the allegations made out a prima facie case, there cannot be a case for quashing. It needs investigation.
Yes.
Your lordship, I just
So
want,
it is at the stage of investigation.
till date, your honor, since the year two
It
thousand
should
and
not be
eighteen,
at
your
this stage.
honor.
Yes.
You know,
Huh?
no charge sheet has been filed, your
You can
honor.
issue notice only,
Yes, your honor, notice may be issued, your honor.
but no
Because,
case.
your honor, in the year 2017 itself, your honor, I have submitted an
It has no connection whatsoever. We don't find any connection with an FIR. What is the page?
Your honor, page number
With an
22,
FIR of 2000.
2017, your lordship.
Where is the FIR?
Page number 19. Page number 19, your honor.
No, the
Annexer 1.
challenge the FIR.
Yes, your lordship.
It is as per the last, my lord, honorable court's order, my lord,
2018.
page 36, if you lordship.
Petition notice heard Mr. S. Sultana,
Yes.
Learned Counsel for the petition, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent. Number 1, State of Assam. Seeking passing of an FIR registered as Varanamukh Police Station, case number 344/2018. Comment the instant criminal petition is prepared, issue notice, return within 4 weeks, and Mr. Goswami, Learned Additional Public Prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam.
Yes.
Issuance of formal notice to the respondent number 1 is dispensed with. Extra copy within 2 weeks. The petition shall take steps for service of notice upon the respondent number 2 and 3 by registered prosecutor AD. Who is respondent number 3?
You know, Sri Konkon Mohanta,
Why?
the IO of investigating officer of your honor, Bharlamukh PS case 344/18, your honor.
What purposes he will serve? No, not required. Respondent number 2 is enough.
Yes.
2 by registered prosecutor AD as well as by AGR processor. But where is the address, madam? He was ACP Jalukbari 2018.
You know,
Is he still there in 2025?
no, your honor, because this.
It will remain in limbo for next 2 years by registered prosecutor AD. Madam, do your homeworks.
Item 49.
May I please along. This is application, my lord, under section 528 of BNSS, my lord. My lord, this is the order, my lord, whereby.
Where is the impugn order?
Impugn order, your lordship will kindly come to page 24, my lord.
Let me read.
Yes, madam.
Yes, Mr. Goswami.
My lord, the petition for extension of time, my lord, it was filed on
179 day, my lord.
Have you read? So annexer 3 is the petition.
Yes.
Yes, 21.
Yes.
Huh? And what does NDPS say? Subsection 4, section 36A. Proviso.
My lord. Provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation of the specific reasons for the detention of the accused but beyond the said period of 180 days.
Do you have any authority on it?
Yes, ma'am.
So it to Mr. Borua also.
It's para, my lord. 18, 21, 22 one.
Para 18 is clear. Para 18 is clear. You go through it. We'll take up tomorrow. You go through it. Reach each word of subsection 4 in the proviso and read this decision and make your submission tomorrow. J.C. Bora, petitioner. R.J. Borua, Land Additional Public Prosecutor. For the respondent states, as on the request of the land conservator parties, list the case tomorrow.
And I'm praying stay of this order, madam.
Huh?
I'm praying stay of this.
Tomorrow.
Yes. I'm deeply obsessed.
See whether public prosecutor has been bypassed or not by the IO. And if you accept the role of this kind of public prosecutor or this kind of IO, then you might be demeaning yourself. So law is clear. So you make submission on it. You will be supporting the public prosecutor in this case. Or the IO. We'll see tomorrow whether you will support the IO or the public prosecutor. We'll see to that. We are waiting to hear your submissions. Whether you'll support the IO or you'll support the public prosecutor. That's why you think it over. I have kept it for tomorrow.
My lord, can I pray, my lord, this bail application also pending, my lord?
Let us see tomorrow.
Lordship.
Pending matters. Item number 12.
Please, my lord, I have filed this petition under.
Item number 12. Yes, madam.
Yes, my lord.
I have
I have filed.
Scratched
for quashing the.
my hair. Too long. But I could not understand ABCD of this petition. What to do, madam? Perhaps Mr. Borua can make me understand. Madam, I could not understand.
This is my lord only Robidas and complaint case, my lord.
I could not understand. Give a copy to Mr. Borua. We'll take up after 10 minutes. If he can make me understand. After 10 minutes, madam. You sit with Mr. Borua to make him understand.
Yeah, please, your lordship.
Item?
With all humbleness, I am before your lordship for pursuant of the impugned order by which cognizance was taken against me, lordship, and the proceeding qua the petitioner, lordship. I've got nothing to do with others. Now, lordship, I will take your lordship to the FIR first. Your lordship will kindly find the FIR in page number 36, annexion number 2. Lordship, it's quite a big and
Big
FIR.
and bulky FIR.
Yes, let me
Long
let me tell the contention, lordship, what has actually happened. Lordship,
You want quashing of what?
Lordship, I want the quashing of the impugned cognizance and the proceeding, lordship.
Proceeding?
For the petitioner, lordship.
What a petitioner?
For the petition. And I will satisfy.
But where is the order?
I'll satisfy lordship why I am seeking so. May I continue, lordship?
Okay, firstly,
Firstly,
I'll
I'm
give
coming to
two
the-
propositions.
Yes, I am coming to the.
I can issue notice
Lordship,
at this stage.
lordship,
This is one,
lordship,
without considering the materials on record.
lordship,
But if I go on considering,
lordship.
then you also run the risk of dismissal in limine.
Perhaps, lordship. I
Both
will-
are open.
Perhaps, lordship, I will satisfy your lordship.
Okay.
Let us try.
Let
lordship.
us take the second, but
Let us try.
you run with the risk.
Lordship, lordship.
I've been doing it.
Lordship, lordship. Lordship, I will just try to satisfy lordship.
No, there is no other option.
Then I will
There
choose
is.
the first option, lordship.
Better.
Lordship,
In a detailed case like this,
Lordship.
long FIR.
lordship. Here, lordship, what has happened?
Short date, since madam is available. Short date, 7 days, 10 days, no way. But if I apply, I'll not apply mine for a second time.
I understand, lordship. Let me go for the first.
Apply my mind.
Let me go for the first
Okay.
option, lordship. Can I make only?
Madam, when can it be made returnable?
Can it be before 19th, lordship? With all
Okay, we
humbleness.
can do it, 19 August.
Yes, sir.
Definitely. Huh? Two weeks will come before 19, so we can do it on 11th of August.
I shall be highly.
Let us exactly find, yes, 11th of August is
Lordship.
2 weeks. We'll prepone it then. 8th of August.
Lordship.
No, we'll not give that license. We'll not give that license to you.
Deployable.
Only if you attend some the Honorable Supreme Court of India will give that license on 8th or 11th. Otherwise not. Or 7th? Yes. Good enough. Heard Mr. A. Vorasaji, Learned Counsel for the petitioner, and Miss M. Devi.
M. Kumari.
Kumari. Learned Retainer Counsel. Retainer Counsel CBA. Post of the petitioner has challenged. Where is the order of taking cognizance?
Lordship will find it is in annexion number 8, lordship.
Page.
8 to 27.
Order dated 1 year back.
Lordship, I am suffering from OSD, lordship. That is the difficulty.
97/2024. Passed in special case number 4/2024. As well as the proceedings. Entire proceedings of special case number 4/2024. Insofar as the petitioner is concerned, where the petitioner has been arraigned as accused number 7. Post of. As issue notice returnable on 7th of August 2025 as MS Kumari, Learned Retainer Counsel CBI has appeared and accepted notice on behalf of the respondent CBI. Issuance of any formal notice is dispensed with one extra copy by tomorrow. But any objection to be filed by the petitioner or by the respondent CBI shall be filed on or before the returnable date. The prayer for interim relief is left open for consideration on the returnable date. You need or not, don't need. Don't need, leave it aside.
Hello.
Prayer for interim relief will be considered on the returnable date. Is left open for consideration on the returnable date.
I'm hello. For this one, item number 24.
And Mahajan, yes.
I have checked
Due
the
to
office
want
of
of
my
address, information has not been arrayed in the appeal memo, and when the appeal the records are being called for, details of the address of the may be available, difficult time. Records received?
No, my lord.
Not.
For office not, my lord. It has not been received.
Then we have to issue reminder then.
My lord.
Heard Mr. D. Bora, learned counsel on behalf of Mr. N. Mahajan, learned amicus for the appellant, and Ms. S.H. Bora, learned additional public prosecutor for the respondent state. Full stop. Here was the office note dated 24/7/2025. Full stop. Issue a press reminder for the records of POXO case number 73/2022. Release the case after 2 weeks.
Public. Item number 25.
May it please your lordship.
Yes,
Lordship.
this is the matter. Issue notice.
Your lordship.
Respondent number 2 has appeared. Yes.
Lordship, before I place the impugned order, I like to place the FIR in question, lordship.
FIR.
FIR in question, wherein seizure has been made. So page, it's from page 11 to 15.
11 to 15.
Page 11, lordship. May.
Page 11.
Yes, this is the FIR, lordship.
Okay, I'll read the vernacular one.
Petitioner have.
Petitioner. Okay, I'll read it. Yes.
So, lordship, subsequently, this affair has been registered under the following sections, page 12. And subsequently, I was also
What is
arrested.
309?
This is regard to robbery, lordship.
Okay. To 126?
126. Yeah. It's 126.
এখন চাৰ্টখন এই অলপ বনাই থৈ
It's
দিবচোন।
regarding
মই
wrongful
বাৰে বাৰে step
restraint,
লিখিব
lordship.
লাগে। অশান্তি হৈ গৈছে।
Wrongful restraint, lordship. So I was not named in the wrongful restraint, lordship, 126. So this was the case. I was not named in that. So subsequently, I was arrested in connection with the case and released also by this honorable court.
What is your
And
name?
lordship, at the time of my arrest,
What is the name of the petitioner?
Farooq Hussain. And he happens to be a businessman in the locality, lordship.
Farooq Hussain.
Hussain. And lordship, during his arrest, lordship, vehicle, which in now question of this petition, lordship, has been seized and in connection with this case, Lordship.
What is the vehicles? Bolero, Scorpio, what?
It is a Scorpio, Lordship.
Scorpio.
It is a Scorpio.
Some Scorpio was mentioned in the FIR.
Yes, Lordship.
Yes.
Though number was not mentioned, but it is mentioned, Lordship. So I filed a JIMA petition in the lower court. So I was there.
Don't say lower court.
Lordship, yes.
Don't say lower court.
Yes, court.
Yes.
So the learned court, Lordship, page 16 is the impugned order passed by the learned court, Lordship. 3.1, may I place that order, Lordship? Today is fixed for anno. Both the parties are petitioners are represented by their learned counsel. Petition number 1, the representative of the SDFC, while petition number so-and-so is prayed for interim JIMA of the vehicle seized by the police in relation to the instant case. Another petition number 2, claiming to be the registered owner of the same by petition number so-and-so prayed for interim JIMA of the same vehicle. The report of IO is received stating that seized vehicle is not required for further investigation. Had learned counsel for both the petitioner and also had the learned APP. The learned counsel appearing on behalf of the petitioner number 1 submitted that higher petitioner number 2, namely Farooq Hussain, has availed an auto loan from the petitioner bank by the application dated 24/2/2024 for the purpose for the purchase of one Scorpio Classic S11 vehicle and executed a hire purchase agreement and with the petitioner bank dated 9/4/2024 with regard to the terms and condition of the loan. And accordingly, the petitioner bank has advanced an amount of rupees 15,59,207 to the higher petitioner number 2 with the condition that the petitioner bank is entitled to take the possession of the said vehicle in case of default of loan installment by him. The petitioner number 2 accordingly purchased one Mahindra Scorpio Classic S11 registered as so-and-so bearing so-and-so. However, after availing the loan from the petitioner bank, the petitioner number 2 defaulted in payment of monthly installments due several times in spite of various reminders, and petitioner bank has recently come to know that the petitioner number 2 has been arrested in connection with the instant case and vehicle was seized by police. The petitioner number 1 has submitted a copy of loan application form, hire purchase agreement, statement of account of annexure 2 and 3, 4 respectively. The petitioner prayed for allowing interim JIMA of the seized vehicle. It is hypothecated to the petitioner bank, and as per the hire purchase agreement, in the event of default of loan installment payment by the hirer, the petitioner bank has the right to take the custody of the seized vehicle. On the other hand, petitioner number 2, Farooq Hussain, prayed for allowing him to take the interim custody of the said vehicle, claiming to be the registered owner of the same. After hearing both sides on perusal of the materials produced by the petitioner, it is appears that the petitioner 1 SDFC Bank is a banking company advanced by loan to the petitioner number 2 to purchase the motor vehicle which was seized by police. The said vehicle was obtained by petitioner number 2 under the hire purchase agreement executed by him in the favor of petitioner number 1. The petitioner number 2 defaulted in payment of monthly installment dues to the petitioner bank in spite of several reminders. In this regard, I would like to lay down this. And then.
Okay,
Lordship,
I have read. What is the law?
now, my lord, by respectful submission, this impugned order, while passing this,
This kind of issue has been settled, I think.
Lordship,
This kind of issue has been settled. Place the authority.
My submission, I want to place a different submission, Lordship, stating that, Lordship, the learned court, Lordship, while deciding this, has traveled out of jurisdiction because the JIMA petition was filed before a criminal court, and that she had no power to look into in deciding the title of the petitioner. So this matter agreement, this was supposed to be deal with the civil
Madam,
court,
I have been
Lordship.
again saying this kind of issue has already been settled. So why don't you place this before making long submissions? Deliberate on it. It is settled. Do you have, when a vehicle which is subject matter of hire purchase agreement, when a question of custody comes, how it is to be decided, to whom it is to be given, law is, I think, settled. There are authorities, I think, we place the authorities. That's all. Facts are clear.
On the ground, they have been paying the loans regular.
That let us, but you have not also taken, prior to that, you have not taken charge of the vehicle. No, you have made the prayer before the court only. Right. Prior to that, you did not exercise the option of repossessing the vehicle due to default on the part of the hirer to make the timely installment. You made the claim before the court only for interim custody, right? Now tell me the authority.
I'll place it on Friday, Lord. I'll go for some, not next week, Lord. Let it be on Friday. Friday, Lordship.
Exact situation has been dealt already.
But Friday, let it be on.
Otherwise, I have to make the exercise.
Yes, Lordship.
I am seeking the assistance of the council.
I'll do that. I'll do that, Lordship.
You not lose the right thereafter also to repossess. But question is, when question of custody of an agreement, find out who is the de facto registered owner. On the prayer of Mr. T. Shom, Learned Counsel, but a petition of Mr. M. Smith, Learned Counsel, but respondent number 2, place the case on. Yes, choose a date, place the authority.
Friday, Lordship.
Friday?
Next week. Friday, Lordship. Let it be on Friday, Lordship.
Friday already. No, let us on some other day. 5th of August.
5th of August.
5th, 6th of August. Huh? 6th of August, kita ase niki? Oh, kita custody ase. And it has 6th of August.
Item 26. Lordship, I'm appearing for the private respondent, respondent number 2. Have only been served with the copy.
Okay, this is criminal revision petition.
Yes, sir. Sir, DW was closed, sir. So we are praying that we maybe DW was closed. So actually we filed an petition.
By this petition,
That we will be allowed to-
petition, file a prayer for adjournment. To allow another person to adduce him evidence on his behalf. That however, declining to grant further adjournment to reduce the evidence on behalf of the evidence has closed the evidence by the impugn order 18.3. Yes.
Yes, sir.
Lordship,
That day he was sick, Lordship, actually. That's why we have.
Then what? Thereafter, what happened?
We have impugn order is at page 16, Lordship. Annex 2. May I read, Lordship?
Yes, we directed you to file additional pleading.
We have annexed some medical documents also, Lordship. He was hospitalized in Name Care Hospital for 3 days. And he also went to Gangaram Hospital.
So whose evidence you wanted?
Accused number 1, Lordship.
Accused number 1.
Yes.
Adjournment 18.3. Where is your, or where is the order?
Order is at page 16, Lordship.
Now I realize that, yes, Because the order says on perusal of the case record, it appears that the case is pending for DW evidence since 21/9/2022.
Yes, Lordship.
Now, why I did not pass any interim order for that reason?
Lordship, actually, we have not annexed the whole order sheet. I have around six times complainant also took a
How much you need? Which cost? How much? You'll get satisfied at what amount? Tell me, what is your submission? Or alternative submission, or that is your only submission?
No.
Okay.
That will be the last comes and it cost.
Only submission. It is not also alternative submission. Right. I gave the option to the learned counsel, whether it is your alternative submission. Now, she said that it is the only submission. So the concession is given. And for ends of justice, we can do it.
Yes, Lord. But
Subject to deposit of 10,000.
Lordship, actually,
Any more submission
Lordship, only one submission.
will be visited at your own peril.
6 times they were absent also, Lordship.
No. Since 21/9/2022, the case was pending for DW evidence, meaning thereby 3 years now.
Yes, Lord.
And on the date, you suddenly failed it. I am not very satisfied with that now.
Lordship,
With that, I am not very satisfied.
we have annexed medical documents.
Whatever. For then other
And other-
default since 21/9/2022.
Lordship, in total 15
In
times.
total 3 years.
Yes, if total 15.
Offense is what? Huh?
The-
No, offense. Defamation. Okay.
Lordship,
So you are a person with the allegation of defaming, that meaning thereby you are also an influential person, perhaps. Guwahati Law Association, what is this? Yes, no criminal cases pending against the complaint. He belongs to respect. He is a member of Guwahati Law Association.
no, that
Who?
complainant.
Complain. And who are you?
I am a member of a border Samaj of Ma Ugratra Temple.
Huh?
Lordship. I am a member of a border Samaj of Ma Ugratra Temple, Lordship.
Ugratra Temple.
Yes, Lordship.
You are also in a position to pay 10,000. Hard.
Lordship, some
15. Mr. Ijbora.
no, I'm just Lordship, kindly one. Okay, Lordship. I'm not praying from otherwise.
Mr.
MJ Gogoi, Lordship.
MJ Gugui, Learned Counsel for the petition. Yes, Miss Bora. Concession is given. S.H. Bora, Learned Judicial and Public Prosecutor for the respondent number 1, State of Assam, and Miss Ann Choudhury, Learned Counsel for the respondent number 2. Best complainant. Post up. The respondent number 2 as the complainant has instituted a complaint in the year 2015 before the Court of Learned Chief Judicial Magistrate, Kamrup Metro at Guwahati, arraying the petitioner herein as the accused number 1 in a complaint, apart from 3 other persons as accused, full stop. The said complaint has been registered and numbered as CR case number 1822/2015. Post of the learned trial court of judicial magistrate, first class, took cognizance on the complaint for the offense under section 499, 500 IPC, and issued process against the accused persons, including the petitioner. Full stop. Para in due course, comma, the trial of the complaint case proceeded with the examination of the witnesses from the complainant side. Full stop. After closure of the evidence from the complainant side, comma, the stage, the petitioner informed the court that the defense would reduce evidence. Full stop. Though the defense inclined to reduce evidence, comma, the stage for defense evidence, the trial is at the stage of defense evidence since 21/9/2022, comma, as recorded in the order dated 18/3/2025 of the learned trial court. Full stop. Para. The petitioner in this criminal revision petition has assailed the order dated 18/3/2025 passed by the learned trial court, whereby a petition preferred by the petitioner, comma, petition number 2734/2024, the prayer made was rejected. Full stop. In the petition, comma, in the said petition, comma, the petitioner stated that on that day, comma, he suddenly fell sick for his high blood pressure, and therefore, comma, he was not in a position to appear before the said court. Full stop. Projecting so, comma, the petitioner prayed for another date for his evidence as a defense witness. Full stop. Para. In the impugned order, comma, the learned trial court has observed that the trial of the complaint case is pending at the stage of defense evidence since 21/9/2022. Full stop. The learned trial court has not found any sufficient ground to grant any further adjournment to the petitioner as the accused number 1 for adducing defense evidence. Full stop. Accordingly, comma, the defense evidence was closed by the impugned order dated 18/3/2025 by posting the case on 3/4/2025 for argument. Full stop. Para. Mr. Gugul and counsel for the petitioner has submitted that as on date, comma, the argument of the case is not over. The parties have not advanced their argument. Full stop. Para. Ms. Chaudhary, learned counsel appearing for the respondent number 2 has submitted that the petitioner has been seeking adjournment time and again, comma, another opportunity can be granted to the petitioner to adduce his evidence in his support, to adduce his evidence. Full stop. When a query is made by the court to the learned counsel for the respondent number 2, comma, whether the same is the only submission, comma, M.H. Chaudhary has categorically submitted that the petitioner is, sorry, the respondent number 2 is granting such condition subject to deposit of a reasonable cost. Post of the complaint case is pending before the learned trial court since 2015. Post of though the evidence from the complaint side has been over, the evidence of the defense side has not yet started. Post of the petitioner okay, the other accused persons who are facing the trial in person, that is the accused number 3 and the accused number 4, have not made any prayer for adducing defense evidence. Post of it is only the petitioner who is standing in the trial as the accused number 1 who has made the prayer for adducing defense evidence. Post of considering the fact that, having regard to the fact that the trial of the case is pending since 2015 and semicolon, the stage of defense evidence and the trial of the case is pending at the stage of defense evidence since 21/9/2022, and the respondent number 2, that's complainant, is agreeable to make concession for allowing the petitioner, that's accused number 1, to grant one last opportunity to adduce evidence subject to payment of costs. This court is of the considered view that for securing the ends of justice, and the petition plus criminal petition, revision petition can be allowed for granting one single opportunity as a last one opportunity as the last opportunity to the petitioner that's accused number 1 to adduce his evidence, post of subject to payment of a reasonable cost. Post of accordingly, this criminal revision petition is allowed. Resultantly, the petitioner accused who is facing the trial as accused number 1 in the complaint case number so and so is allowed to adduce his evidence on the next date of listing of the case.
6/9.
That is 6/9/2025.
Sorry to interrupt, Lordship. Lordship, we have filed a list of witnesses also in case, Lordship. About 3 to 4 witnesses are there in our.
It was, the order is only for you.
Yes.
Nothing else. You made a prayer at that time. So on the next date of listing, 6/9/2025. Subject to deposit of an amount of rupees 10,000 on that day, as such amount is found to be reasonable in the considered view of this court. On deposit of such the said amount of rupees 10,000 by the petitioner, the accused number 1, the said amount is to be disbursed to the complainant upon due receipt with the observations and directions. The observation made and direction given above, the criminal revision stands allowed to the aforestated extent, to the extent indicated above.
Please, my lord.
Yes.
Find this case for quashing the complaint case, my lord.
Complaint case.
CR number 73.
Yes, Mr. Borua, please.
The husband and wife, they paying for the husband. My lord, opposite party is the complaint case. Okay, so there is that, my lord. Husband and one, the wife, she purchased some clothes of wealth. The husband, my lord, without her consent, without her much.
How can, if she has purchased the land in her name, how can the?
Allegation, my lord. That is the civil nature case, my lord. So it is not the attack in criminal case, my lord.
Your wife or husband?
I am for husband, my lord. Case is filed, complaint case is filed, my lord. Wife, my lord.
You are still in relationship?
Yes, my lord.
Still in relationship, living in the same house?
Same house, my lord.
Same house?
Same house.
That is not true, my lord.
Huh?
Husband, my lord, yes. That is separately, my lord.
Rented house, my lord.
To some other day.
That is the allegation is false, my lord. He suspect the husband that he is relation with another.
But your husband, wife.
Yes. And that is the civil.
Yes, 31 years.
Yes, my lord.
Huh?
31 also.
Marriage.
Marriage
You have a 28-year-old son.
Son, my lord. Yes, my lord. That is
Now dispute arising now.
now, my lord. So it is the false allegation.
Purchase a plot of land measuring so and so.
In this stage, my lord.
Any of the complainant constructed the house suddenly. In the complaint, who is the accused?
Robi Das, my lord.
Robi Das. Petitioner.
Petitioner, my lord.
Oh, the
That after marriage, complainant purchase plot of land, my lord.
when it was sold, madam?
Because he's the business.
What is the land?
Land is already.
What is the land details?
Land details. That is
When it was sold?
not sold, my lord. That is the that their fear, my lord. They stated in the complaint case, my lord, page 3, my lord. The present paragraph 10, my lord. Page 3, page 9, my lord. Page 9. In a complaint petition, paragraph 10, my lord. Yet presently they are staying on the said land. They are already they are staying in the said land. How can I sold it? That the opposite party is the drunkard, and from the very beginning of their marriage, he used to torture her, and considering the future of son, complainant had to bear all 3 years. That from last 4 or 5 years, opposite party is not staying with us. Complainant and staying with that woman in various times. That is the suspect, my lord, not the false statement. Only the harassment they have filed the case, my lord. Already she have filed another maintenance case, my lord, and they are received the maintenance from the petitioner. That is the all complaint case, my lord. That is the civil nature, not the any such type of criminal kidnapping. And trial court has issued summon the opposite petitioner, my lord. So that it is appeared, my lord, and at this stage, case is at the stage of evidence, my lord. So I
Evidence.
evidence. So I have
You have appeared.
appeared, my lord, in trial court. Subsequently,
What harm to continue the trial?
because the case is not such primary issue, my lord. In this, as per the complaint petition, my lord, all allegation is that the land dispute, my lord. That is the civil nature case, my lord, not a criminal.
Opposite party, opposite party means, my lord.
R. Miss
R. Kolita, my lord.
R. Kolita, learned counsel for the petitioner, Mr. R. J. Burua, learned additional public prosecutor for the respondent number 1. Okay. The petitioner has preferred the instant criminal petition seeking passing and setting aside of the proceedings of complaint case number 7304C 2022, which is presently pending before the court of
Judicial Magistrate First Class, my lord, Kamrup.
Judicial Magistrate First Class, Kamrup. Metro, Guwahati. Was the petition notice returnable in 4 weeks. Why you realize after 3 years that it is a case for passing? Petitioner shall take steps for salvation of this of the respondent by registered procedure as well as by the usual process within 3 working days from today. Why you have
Because when
57.
Selimul? Yes, Daddy.
My lord, yes, my lord, yes, that was confirmed. That is not updated. It's from this, my lord. Lordship development of the statement.
That day we deliberated, right? Something
Lordship.
about case diary?
Yes, ma'am.
Entries up to something March or something like that. Oh, when? Wednesday? Wednesday.
Lordship.
Here, Roman, petitioner present. Mr. Sharma and additional public prosecutor has submitted that updated case diary, as called for by the order dated 22/7/2025, has not yet been received by him. He has sought listing of the case and he has sought listing of the case for an updated case diary on so and so. When is it?
30.
Or when? Tell me.
No, it's correct. 30, no?
Or 1st of August.
First of all,
Oblige.
28.
First time.
May I please?
Statutory appeal. First time.
Yes, Lordship.
Heard, Mr.
R.K. Mohanto on behalf of
R.K. Mohanto, Learned Counsel, appearing for the appellant, and Mr. A. Sharma, Learned Additional Public Prosecutor for the response number 1 state. Full stop. So is your petitions? Appeal. This criminal appeal under section 415 Bharatiya Nagarik Suraksha Sanhita 2023 is preferred against a judgment and order dated 8/5/2025 passed by the Court of Learned Special Judge Poxo Tinsukia in Poxo case number 43/2019, which arose out of Dunua Police Station case number 331/2019. Post. By the judgment and order dated so and so, the accused appellant has been found guilty for the offense under section 4(1), Protection of Children from Sexual Offences Act, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of which 10,000, in default of payment of fine to suffer simple imprisonment for another 3 years.
3 months.
We have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The records of POXO case number so and so be called for issue notice returnable in 4 weeks. As Mr. Sharma has appeared and accepted notice, additional public prosecutor has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issues the formal notice to the respondent number 1 is dispensed with. The petition accused appellant shall furnish extra copy memorandum of appeal and with an extra to Mr. So-and-so within 2 working days from today. The accused appellant shall take steps for service of notice upon the respondent number 2 as informant in terms of the practice direction. So-and-so, the learned additional public prosecutor is to obtain a report as regards service of notice upon the respondent number 2 as informant from the officer in charge so-and-so police station and to place the same before this court on the returnable date. There is no application. No application. Once an application, you will file an objection.
Oblige.
29.
May it please your worship. Matrimonial dispute between husband and wife, my lord.
Matrimonial.
Yes.
Matter
Matter of 2013, my lord, still going on. What happened in this case? The wife has
some
filed
reflection of name.
Yes, yes. My name
Done.
is
Now. Okay. Oh, your name.
yeah. My name is
Oh.
not been reflected in the court.
Now reflected or not?
I don't know, my lord. The order dated 9/6 reflects it, my lord.
Verify the Okalnama and reflect the
Yes.
names.
Yeah.
Okay, what happened now? You tell me.
Anyway, my lord, 2013 dispute between husband and wife. Multiple litigations, my lord, went to Supreme Court also. Now happens to be that prosecution that wife evidence is over. Now the
What kind of case?
Maintenance, 125%.
125.
Yes.
Yes.
Now the wife files as per Rajnish and Nehar judgment with regard to assets and liability. That is at page 41. After filing of this, my lord, she doesn't disclose her PAN number also. And no details has been provided. And as such, she has been stating that her plea is altogether is this, that she has no income. So the court has granted interim. I am all along paying. Even my lord at 9/6/2025, when this interim order has been passed, my lord, I stated to the honorable court that I will continue to pay the maintenance. But this cannot be this way. So this respondent husband, my lord, came across with the acknowledgement, my lord, with regard to paying of income tax to the tune of rupees 2 lakhs yearly, my lord. That we have annexed in. We have a copy of it. So we under invoking section 91 as because it's a private document and it's not a qualified privilege is being applicable. The court has always the power to call for this. So that petition has been, my lord, dismissed, and as such, I am before this honorable court. May I take your lordship to the order that's been passed? That is at page 133, my lord.
120?
133, my lord. Last annexure, my lord.
33.
Annexure 18. Yeah. The opposite party filed an application number 80 of 25, this petition, my lord, by which he has prayed to direct
Opposite party, okay, 80 of
yes,
2000.
the husband, my lord. ITO admission so-and-so Akash Bhavan, Christian Basti, GS Road, Guwahati, so-and-so to produce the file pertaining to PAN number so-and-so. She has not disclosed her PAN number in the assets and liabilities also. Belonging to the petitioner pertaining to the assessment year 2021 and 22 with acknowledgement number so-and-so and also pertaining to the assessment year so-and-so with acknowledgement number so-and-so and also pertaining to the statement of other financial years being FY 12 to 13 to 24 so-and-so pertaining to the petitioner bearing PAN number so-and-so, my lord. The opposite party filed another application number 81 of 20 by which he has prayed to direct the Muslim Marriage and Divorce Register Guwahati to appear as an official witness in the instant case along with the records pertaining to so-and-so of marriage of the petitioner with Mr. Sokat Ali on 11/6/1987 and or further send the specimen signature of the petitioner to FSL to compare it with the signature of the Kabil Nama, it will be Kabil Nama of the marriage between so-and-so, so-and-so. Means, my lord, it's been a plea of the husband, my lord. During the subsistence of the before the subsistence, she was married to another person. Hard amicus curiae, so-and-so, so-and-so. I have also gone through the application number 80 of 25 and 81 of 25, and in my view, the prayer of the opposition cannot be considered at this stage because it will not help for just decision of the case. My lord, may I stop here, my lord? Maintenance is with regard to reasonableness, with regard to income. She says she knows she have no income, whereas I produce materials on record to show that she's been paying income tax annually 2 lakhs. Her income is about 18 lakhs per year, which is filed by the wife. It will not help.
Monthly income 2 lakhs, you say.
My lord, annual income is 18 lakhs. So income tax payment, my lord, is been reflected in the acknowledgement. I'll take your lordship to the acknowledgement, her acknowledgement. And it shows that if a person is been paying, my lord, now as on today, my lord, the law is this 12 lakhs, there is no tax. 12 lakh to 16 lakh, one has to pay 15%. 16 lakh to 20 lakhs, one has to pay 20%. 20 to 24, my lord, it is 25. Then above 24, it is.
She paid how much?
She paid 2 lakh, and at that moment of time, it will be about 18 lakhs income. And she is saying she has no income, my lord. And that's why, my lord, this has been.
Why the trial court is saying timeline by the Honorable
Yes,
Supreme
that
Court?
Supreme Court order at page 41, my lord. Please, Kiman. 99, I'm sorry. Yes. 99 is the case, my lord, with regard to this, my lord. And last paragraph 14, my lord. Having considered the above and submission of the learned counsel, we are of the view that the further indulgence of the to the respondent in this contest to the maintenance proceeding to the petition should not be shown. The court must take for disposal of the criminal case number so and so
on or before 12/6. This petition was filed prior to 12/6, my lord, no? 12/6. As has been permitted by the High Court under the impugned judgment, the respondent is expected to cooperate in the proceeding, and the learned court is requested to also ensure early disposal of the maintenance case. It is ordered accordingly, my lord. This is the order, my lord. And he filed his evidence, and apart from this acknowledgement, my lord, may I take your lordship to the acknowledgement card, my lord, which every taxpayer, my lord, gets it. my lord.
21/6/2024.
Yes. My lord will kindly come to this acknowledgement at page 118. Wife address, everything has been there. PAN number has been reflected, my lord. Everything has been there, my lord. And she's been paying how much income tax, it has been reflected, my lord. This is of 22. Next page, my lord, another, my lord, at page this one. And we intend to say this, my lord. That
Where is the page?
Page 118, my lord, will kindly come. 118. Assessment year 21/22, my lord.
118.
118, my lord. This is tax returns of her.
Where is that reflection?
Yes. 21/22, my lord, will kindly see. 2,24,200. Adjusted so and so, book of so and so under AMT where applicable. This much of tax has been
This is
paid.
total income. Income?
Yes, my lord will kindly see the installment that has been
No,
paid.
you
The
said
money,
2 lakh paid, 18 lakh income. But here it is total income. 118.
my lord, as for the instruction, my lord, it is about.
No, this ITR, man
Yes,
may
okay.
lie, documents don't lie.
My lord.
Page 118.
Yes.
Total income, 2,24,000.
Next page, my lord, will kindly see. Next page will see the
May have increased to what?
4
It is
lakhs.
not
4 lakhs.
in the range of 18 lakh.
Yes. My lord, maybe 18 lakhs, maybe 4 lakhs. But the question out here, that in assets and liabilities, as for Neha's judgment, my lord, everything has to be disclosed.
Whether asset and liabilities, ITR was mentioned.
No, yes.
Where
ITR 3 years returns, my lord.
Where is it?
That judgment. Copy for this, huh? Yes. Judgment to copy to the 9. Copy to this one. Every details, my lord, has to be provided.
Where is that?
Yes. That's one page. Yes. Details, my lord, with that page 385, my lord. 72.6. No, 72.6 is different. Yet the detail of income tax at page 386, my lord, will kindly come. Details of
Yes, Mr. Ali.
income of the department.
They are saying your income tax pay, you submit IT return. Then you are required to fill up this particular, whether assessed to income tax. What did you reply?
Actually, my lord, company is my lord.
No, I am asking you this question first. Then you make your submission. How did you, if you have filed your statement of assets and liabilities? Oh, how you filled up? Whether assessed to income tax? Yes or no?
No, my lord.
No. If yes, submit copies of income tax return for the period given below. 1 year prior to marriage, 1 year prior to separation, at a time when the application for maintenance is filed. Right? So at least this much. And if it is, then you are not tracing the true facts.
The PAN number was not disclosed. The assets and liability. It's required to be disclosed. Page 41 of assets and liability.
Where is your statement of assets and liabilities?
My lord, her statement.
And the respondents.
Page 41, my lord. Page 41, her, my lord. 41 is the affidavit, my lord. On affidavit, my lord, and even there judgment, it has been provided, my lord. If a person files false one, then shame shall be liable to perjury, my lord, because it's a court of law, my lord. Here, my lord, you kindly see. Everything has been provided, my lord. And And this has to be enclosed by the bank statement of 3 years and income tax return of 3 years. Nothing has been given, my lord. And says, I
You
have
maintain how many residents,
my lord.
Mr. Ali? You maintain how many residents? Oh, this is Alhaj. Where is the wife?
This is wife's, my lord.
Page
41.
40.
Rehana Begum, my lord.
Separation monthly 50.
So submitted on 15 December 2021.
My lord.
21. Okay. Where is the ITR part?
ITR part.
Page, my lord.
Page 47. Come to page
Yes,
47.
Page 46. Details of income tax of the department. not-
7. Whether access to income tax, why it is not applicable? On the contrary,
Now, my lord.
this ITR may be required for the just decision of the case.
Absolutely. That's what.
These, my lord, asset and liability was, my lord, furnished on, my lord, 2021.
They are referring to 2021 only.
Yes.
Come to page 118.
21, 22.
Assessment year, meaning thereby the income you got in the financial year 2021. If the assessment year is okay, what is the two term? Assessment year and
Financial year, my lord.
financial year.
1/4.
So which one is assessment year?
Assessment years is 1920. This return has been filed, my lord.
Maybe
21, 22 at page 18.
at the time, this is the one
Yes.
date of filing.
Yes, my lord.
30 March 2021. Or what? Date of filing is mentioned there. Page 118.
2021, yes.
Date of filing is
30th of March 2020.
22. Okay. So, whether access to income tax.
Oh, my lord. Here, my lord, in my son, my lord, he has to stand out abroad. His father, my lord, refused to give his PAN card money. His income with it. So, my lord, his income, my lord, was, my lord,
Whether he has, Mr. Bhuya,
this, my lord,
before throwing stone to your wife's glass house,
my lord.
what did you state?
My lord.
What did you state in your
Assessment liability?
Yes.
Everything has been provided.
Let us see.
Page 55, my lord.
Let us see your statement.
55, my lord. He's a government servant, my lord.
Government servant?
Yes, yes. He's a doctor, my lord. Everything has been given, my lord.
Okay.
Everything has been provided, my lord.
Where is that one?
55,
Income
my-
tax part?
50, yes, income tax part, my lord. We can come to medical details, my lord. House rents, furnished bank statements, enclosed, my lord. Income tax reply enclosed, my lord, at page 60.
Page?
60.
60.
Enclosed, my lord. Details of income tax, page 59, it continues, my lord, to page. Nothing to hide, my lord.
Why you were a student?
My lord.
Why you were a student?
At page, my lord.
60 only?
60.
answer is no, my lord.
He was doing MD, my lord. That's been instructed by the, my lord. With, yes. Student, MD student, and been like maybe a, my lord, register.
So whether access to income tax?
Yes,
You
it's
said
been,
no.
yes, yes.
You said
Yes.
no.
Enclosure 4, my lord, will see. whether
No,
assessed to
seven-
income tax,
seven-
yes,
seven.
subject so and so, during 1 year
Page
prior to.
60, page 60, question number 7.
Yes. Question
Whether
number seven.
access to income tax.
Yes, no, during, prior to marriage. No, during 1 year of marriage and 1 year prior to separation, the deponent was a student. But when the maintenance was filed, yes, the deponent had filed ITR so and so. So.
What is your reply, Mr. Ali, at the time when the application for maintenance is filed? Whether access to income tax?
No one. The petition was filed on 18 to 2013. 2013, my lord. And my lord, OP appeared on 4th 2013.
Okay, at that time of filing the maintenance petition in the year 2013. Okay,
And my lord, OP appeared on
Okay.
2013.
so since when you have started submitting ITR?
And only for this 2 years because for sending the son to abroad for specs. Because the father did not provide anything. Neither his
And
father-
your children is studying what?
But now, he's doing my lord MBBS. man.
Your son is doing MBBS. And at your own cost you have sent.
Oh, one of the great grandparents. man. Grandparents is.
So this is required when at the time when the application for maintenance is filed.
No, my lord.
No,
We do not-
Rajni's
My lord,
form.
My lord, what I am.
No, Rajni's form.
Yes. At the
These
time
are
of
the columns.
Absolutely right. But if there is change in circumstances, it has been their duty to inform. Apart from that, my lord, what I am on, that
It cannot be said that
We
1
cannot
year
say-
prior to marriage, 1 year prior to
no,
separation.
we do not know, because in the affidavit, my lord, it's been stated a plea has been taken as such now, and she has been subject to cross-examination. Now, there is
Because question of maintenance should relate back to the period when they got separated, when the lady
Absolutely.
had asked for
Absolutely, my lord.
maintenance.
Yes.
Not with protracted litigation for 12 years.
That's
At the stage of filing this Rajni's.
Yes.
Rajni's came into 2020, thereafter all these forms.
Yes.
But at the stage, we have to relate back to 2013.
That's true. But what I am on, we do not know what they are saying. It's been a matter of record. And I am not the authority concerned. A person, my lord, appears to be, my lord, at 2025 saying she has no income. Whereas from the record it comes in, we put it on record. And they are not disputing that it is not been income. So let us before the court. And with regard to sufficiency, with regard to, my lord,
Let me go to Rajni's, we'll decide on another date. But situation
Yes.
is not that as projected.
no, my
Can you see the conduct of the.
my lord, at any point of time, my lord,
Granted, my lord, time limit, my lord. Because my lord, he is taking 6 years to, my lord, cross-examine the petitioner.
We have to go through the petitions, entire brief.
Yes, my
We
lord.
have to see the conduct
What
also
I am
of
on,
both
my
the
lord,
parties.
in a maintenance case, my lord is very much right. At the time of my lord filing these assets and liability, there can be change in circumstances. But the final order is to be passed on the basis of evidence on record, my lord. Why the honorable court, lower court below, can stop me from adducing evidence and to put the best evidence before the court? We do not know. They are saying that 11,
We'll
12,
see
13.
whether it is the best evidence or not, whether it is required or not.
My lord, it is on record. Because if it is not been brought on record, even in spite of the fact they are admitting that this has been the income tax return of the wife, in that case, the final order, outcome of the final order is affected. Because
What
if
was
we
the
have.
prayer? What was your prayer in the petition?
Yes,
Let us see
petition
once again.
page go. One two two, my lord, page number 91, my lord. Very, very reasonable prayer, my lord, and nothing else to put on record. ultimately court will come to a finding, my lord. A person may not be employed in 2013-14, but can be employed and sufficiently having reasonable income. Then that ultimately affects the very judgment of the court, my lord.
Mr. Ali, when the evidence of your side was closed,
The petitioner submitted, my lord, evidence on, my lord, 6/4/2016. And they, my lord, took 6 years to, my lord, cross-examine. And cross-examine.
No, I got the license pending was in-
4/6/2022.
hmm.
Then, my lord, on 10/4/2023, my lord, case is for DW. And,
Why it took 3 years?
My lord, in between, my lord, the matter came to High Court also, my lord. And there was stay order, my lord.
When you adduced your evidence examination in chief,
Examination, my lord, on 4/6/2016.
4/6.
6/4, my lord.
6/4. You said 1/6/4. Why 4/6 then?
6.
So it took the opposite party to 6 years to complete cross examination. 6 years.
6 years. He remained every day absent.
Hmm.
To admit.
Hmm.
And cross examination completed on 4/6.
Hmm.
2020.
Hmm.
Then, my lord, case for evidence of DW on 10/4/2020.
Hmm.
He remained absent, my lord.
Hmm.
Then,
Are this testimony of this petitioner in the 125 that is respondent is available here? Available here, testimony.
Petitioner or cross-examine too. Lokwan, right? Please call.
cross examination case for 105.
No, petitioner, this
Wife.
wife.
Wife. Not an expert.
2013.
Wife to 9.
Do you have the order sheet?
No, my lord, I don't have it.
I have order sheet from, my lord, from the date, my lord, given by the council people. They also put 6 month time to complete the court. Then he filed petition for transfer the case from that court.
Okay. You filed objection? Anything? No. What is the interim order?
Other proceeding has been stated.
Here in this case, and that particular maintenance, my lord, it's not been stayed, my lord, and I have submitted to the court. Yes. Yes.
Okay, you place on record whatever is required to be placed on record from your side. When will you decide? This cannot go on since 2013.
My lord.
One way or the other.
Yes.
If it is protracted since 2012 or 13, it must come to an end.
Yes, of course.
And should kindly see the announced court order from Supreme Court, my lord, directed not to give any indulgence.
Place your records, whatever is not placed by the petition.
I need
I
a,
have filed, my lord, petition, my lord.
You place on record what is not placed by the petition. Then we'll
nothing.
balance. We'll balance.
My lord.
We'll find out
My lord. And one thing, my lord,
which side the weight is
my lord,
more.
let them file a petition, my lord, with regard to the income tax acknowledgement, whether it is a genuine or it is.
Will not force them. Let them place whatever place them, force them to file.
My lord.
This is otherwise personal.
My lord.
Whether it is required for a just decision of the case or not, that we have to decide.
Yes, yes. Ultimately,
No,
it's
you
a
cannot say
reasonable-
that. I cannot say.
I leave it to your
Let us
lordship, my lord.
decide whether ITR is required to be placed for just decision of the case.
My lord, that's
That
true.
is the only question.
That's true.
And we have to whether it is to be related back to 2013 or
My
not.
lord.
You submit your response within 1 month, 1 week or 2 weeks.
Wednesday, my lord, I have already, my lord.
Not Wednesday, which is too heavy now, next week. Don't
Yeah,
place
this is a
such burden.
14.8. Maybe 14.8, my lord, if your lordships allow.
We'll put it on 13.8.
13.
If you submit, we'll decide. Maybe we roll over to 14 also. Heard Mr. A.K. Bhuyan, learned counsel for the petition, and Mr. R. Ali, learned counsel for the respondent. Post of the respondent
1-4.
is given opportunity till 12/8/2025 to file its response. List the case on 13/8.
My. On 14th, my lord,
The interim order passed, the shall continue.
14 will be listed.
13 will be listed, given opportunity.
14 both.
If it is filed, we may require.
My lord. Obliging.
Item number 30.
Till Singh Low Tuler.
Item 30.
Prefer setting aside criminal proceeding corresponding to students of such as in flight on notice was issued. Anybody else apart from state? Offense is Arms Act. If it is Arms Act, there is no representation on behalf of the petitioner today on call, Mr. A. Sharma, B. Sharma, learned additional public prosecutor for the respondent state, is in attendance. Oh, it was submitted that the matter has been amicably settled. Okay. Oh. So it is for you. Basically, petition number 1 and a petition number 2. They have amicably settled. They are husband and wife or something.
Is also there.
But looks like
They will look at my lord, please.
we'll see when the petitioner is present. As there is no representation on behalf of the petitioners, right? Silo will check with size equity on today. Let the case for ends of justice be listed after 2 years.
This item number 50.
The maintenance case, lordship, 125, lordship. Call for the records, lord.
Mr. N. Ahmed, learned counsel for the petition is present. Though the learned counsel for the sole respondent have entered appearance by filing Okalanama, comma, there is no representation on behalf of the sole respondent today on call. Post of and be of non-representation. Such non-representation, let the case come up for ends of justice be listed after 2 weeks. The interim order passed idea shall continue till the next set of listing.
For orders. Item 31.
Omorendra Fukan as for yes.
Lordship, the
Please with the necessary report of the science and the poster of the further service of that is. What is the offense otherwise?
is 451 and 354 IPC.
451.
451 and 354.
451 is what?
For trespass, criminal trespass, and 354 for
Okay.
molestation.
Heard Mr.
Yes,
S.S. Burwal, learned counsel for the appellant, and Mr. B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam, to stop. Peruse the order dated 16/7/2025 of the Loajima Court, post of para. As per order dated 16/7/2025, of the Loajima Court, service of notice upon the respondent number 2 is complete. Post of. As none has appeared for the respondent number 2 on call, let the case be listed again for in the orders column for appearance of the respondent number 2. Full stop. It is observed that in the event of non-appearance of the respondent number 2 on the next date of listing, court may consider appointing legal aid counsel. So, make us query to represent the respondent number. Well, since 354 is involved, we may appoint amicus after 2 weeks.
32.
May I please, Lordship, kindly allow us to take a fresh step.
Mr.
S.K. Bhattacharya.
S.K. Bhattacharya, learned counsel for the appellant.
On respondent number 1.
Heard. So it's for the appellant. And Mr. B. Sharma. State, we can give a cycle. Peruse the office note dated 24/7/2025. Poster. Mr. Bhattacharya, learned counsel for the appellant, has sought an opportunity of 3 days to take steps upon the respondent number 2. In the respondent number 1 or what?
Number 1.
It is not, state is not a party. Or state is a party.
State is a party. Respondent number 2.
Respondent number
2.
2, Sorry, bole. I'm going to respond number 1. In deference to the order dated 12/12/2022. Release the case of the police. Issue a reminder for the TCR.
33.
My lord, in this case, though I have filed a leave petition, my lord, nowadays it is not necessary, my lord, as per the judgment of the Honorable Supreme Court, my lord, passed in the month of April, my lord. Recently also, my lord, few days back, I have filed such type of cases, my lord, and it is disposed of by the Honorable Court.
Am I or what?
Yes. My lord, in the judgment, my lord, number 2.1. Yes, my lord.
Then
Then, my lord, I have pointed out in 3.11, page number 4,
3.11.
page number 4. Then 3.12, 3.1.
1 minute. 3 point.
3.
What is the answer?
My lord.
Answer.
My lord, in the last, my lord. Page, my lord, 26.
Para?
Para 7.12.
7.12.
12. And in the fifthly, firstly, secondly, thirdly, and in the fifthly.
Oh. Now, what order is to be passed?
Now, my lord, it is not necessary, my lord. So I have also placed a decision, my lord, of the Honorable High Court, my lord, recently passed, my lord, in one of my case, my
And
lord.
what is the period of limitation there?
My lord.
What will be the period of limitation?
Limitation, my lord, already it is filed, my lord. I have
File?
Yes, my lord.
But judgment and
As
filing
per
of
the judgment, my lord, filed within a period of 4 months.
4 months.
Yes, my
Where
lord.
is-
Last page, my lord.
Last page.
Yes, my lord. Para 11, my lord. Sorry, 12, my lord.
Okay.
Now, my lord, the complainant in such a proceeding, my lord, will be treated as a my lord.
Same, then we'll pass the same order.
My lord. I have also.
And this is to be registered. Appeal
Yes,
is to be registered.
Yes.
Yes, do you have anything to say? I had Miss N.S. Thakuria, Learned Counsel for the appellant. And who is for the respondent? B. Sharma, additional public prosecutor. Respondent number 1, state of Assam. And Mr. A. Bosumatre, Learned Counsel for the respondent number 2. Post of the instant criminal petition was filed under section 374, 378 within bracket 4,
Four. CRPC.
comma Code of Criminal Procedure 1978, seeking leave to prefer an appeal against the judgment and order of acquittal dated 29/8/2023, passed by the Court of Learned Session Judge Nalbari in Criminal Appeal number 23/2022. Post of para in a recent decision on the Honorable Supreme Court of India. In a recent decision in Celestium Financial, titled Celestium Financial versus A. Gyanasekaran etc., comma, reported in 2025, SCC Online, SC 1320, comma, the Honorable Supreme Court of India had framed the following question, para 2.1. In answering the question, comma, the Honorable Supreme Court of India has held in paragraph 10 of the judgment that the victim of an offense has the right to prefer an appeal under the proviso to section 372 of the CRPC, irrespective of whether he is a complainant or not. Full stop. Even if the victim of an offense is a complainant, he can still proceed under the proviso to Section 372 and need not adhere to subsection 4 of Section 378 of the CRPC. Full stop. Where in view of the aforesaid proposition of law laid down, the present petition is disposed of accordingly. Full stop. The registry to register the connected appeal and after to list the same for admission after 2 weeks. Not after 2 weeks, accordingly. Maybe I have a meeting, yes. (47) IA criminal petition. Some other date? Not tomorrow. I may, madam, please understand my difficulty. I'll be sitting in a division bench. All right, please understand my difficulty also. It is not that I do not want to do it. Demand urgent.
Item number 36, madam. Item number 36.
It is a criminal petition.
Any date, madam.
By reverse short for students. 36, 47.
My lord, 42, my lord, for praying for bail, my lord. Criminal appeal, my lord. 2 years.
Criminal appeal. 42. ठीक है side वो 42.
Any date, my lord.
Let him.
My lord, item number 46, my lord. Item number 46, criminal petition.
Okay. ठीक है 46 तो side वो.
Deeply obliged.
The last official, 21/7, observed that. Therefore, an urgent consideration is called for.
Okay. Side huh?
In item 51, there is a plea of juvenility, you know.
Okay.
Item number 40, my lord. That may can on Thursday, my lord. Already informant has appeared, my lord.
Okay, some other did not this week.